Page 1, 1 to 8.
Item number 3, let's see. Kindly next to it.
Item number 7, my lord, I am on VC. I pray some other day. I pray some
I
other
pray,
day.
I
am not
pray,
keeping.
I pray I have to go serial.
I'm sorry, my lord.
But I am not sorry. Item 3 lekon tu.
I think.
Who is for the vigilance, sir?
Yes,
Yes.
Your name, sir?
Sanjay Kumar Das, standing.
Oh, yes, you are there on record.
Yes, ma'am.
C6 adjournment, Mr. Das. Could you follow what she made, what she submitted? C6
Yes.
adjournment.
Yes.
Tanima Kumari Dei for the petitioner. Mr. Sanjay Kumar Das, standing counsel for vigilance. For OP. Standing counsel vigilance for OP. The matter being in the list is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding seeking adjournment. The matter shall be listed for fresh admission in the week commencing
27.
27 is the 27 2026.
Okay.
7.
My lord, I'm for the petitioner. I am not keeping well, your lordship. I pray if my lord may keep it to some other day.
The matter was listed on 30/3/2026 and adjourned by the learned counsel for the petitioner. Again on 27/4/2026, the matter was listed and adjourned. Today, the matter being in the list for fresh admission is mentioned at the beginning of the day's proceeding, item 7, by the learned counsel, Mr.
For the
Subhankar
petitioner.
Das,
Yes.
seeking adjournment on the ground of personal difficulty. To grant further opportunity, the matter shall be listed in the week commencing for
27.
fresh admission in the week commencing 27/2026.
Grateful, lordship.
Page 2, 9 to 18.
Item 13, my lord. It will be listed in the next, you may be listed in the next one, my lord.
Mr. Ashwini Kumar Das for the petitioner. Matter having been listed for fresh admission is mentioned by the learned counsel for the petitioner. Seeking adjournment on ground of personal difficulty, the matter shall be listed for fresh admission in the week commencing.
Maybe, my lord, next week, my lord, either 13 or 14, because 18 is the date
Sir,
fixed
13
there.
days are 133. See, 27 से कहीं पहुंचे नहीं जब first 137, 129, then 27 is 108. So Monday 108 is a good number, but he's adding to that. 27 asu.
My lord, 18 is the date fixed there, my lord. Therefore,
So we commencing 13
oh, yes, sir, my lord. 13. Oh, 13.
We commencing 13.
Item 10, Milords.
Mr. S.C. Puspalaka. 13th of for the that is Mr. Subhashchandra Puspalaka, item 10.
Stocks with record. Last occasion also I had taken time, Milords. One urgent address.
The matter being listed for fresh admission is mentioned by the learned counsel for the petitioner seeking adjournment to grant further opportunity. The matter shall be listed for fresh admission in the week commencing
27.
27.
Milords.
Yes, next please. ये 14/18 17 कौन है सर आपण गोटे मेमो फाइल करछन दैट इज ऑन रिकॉर्ड योर नेम सर कौन ना बट ना तो आपण को थिबो ना आपण ना केमती नाही आपण तो बार काउंसिल रे भी अछि आपण आपण को ना सर कोन विद्याधर टा गोटे शब्द बुझले इंग्लिश रा अपभ्रंश काई कले विद्यां धारयति इति विद्याधर आपण तो बीडी कर देले ଆପଣ କେବେ appear କଲେ? Mr. ଶତପଥୀ ଆଉ Mr. ମହାନ୍ତି consent ଦେଇଛନ୍ତି? ନାଇଁ ଏଇଟା ସାର୍ ସେଠି ଫାଇଲ ହବ, ଆମର ଏଠି କାଚରେ ଭାଙ୍ଗି ହବନି। ଫାଇଲ କରିଛନ୍ତି? କେବେ ଫାଇଲ କଲେ ସେଟା ପଚାରୁଛି ଡେଟ୍ ସାର୍। 7/5 ଓକିଲାତନାମା ଫାଇଲ କଲେ। ମେମୋ କେବେ ଫାଇଲ କଲେ? ୱିଡ୍ରଲ୍ ମେମୋ ସାର୍, ୱିଡ୍ରଲ୍ ମେମୋ। ଫ୍ଲାଗ ଇ ନହେଲେ ପୁଷ୍ପାଳ କାଇଣ୍ଡଲି ଜଷ୍ଟ ଶୋ ହିମ୍। ଟିକେ ଦେଖିଏ ଆପଣ ୟୁଜ କରୁନାହାନ୍ତି କି? କଣ ଆଜ୍ଞା ଆପଣ ତ ବି ୟୁଜ କରୁନାହାନ୍ତି। ଫ୍ଲାଗ ଇଟା ଟଚ୍ କଲେ ଏଠି, ନହେଲେ ଆପଣ ଏଠି ଆସିଷ୍ଟ କରନ୍ତୁ। ଫ୍ଲାଗ ଇ ରେ ଦେଖଉଛି ଗୋଟେ ମେମୋ ଅଛି, ସେଟା C5 କରିଛନ୍ତି, ଦେଖିବେ ଆପଣ ସେଟା ସାର୍ ମୁଁ କହୁଛି। ମିଷ୍ଟର ସାହୁ ଆପଣ ଦେଖନ୍ତୁ ସାର୍, ସେଇଟା ଆପଣ ନା ଆପଣ ଅଡିଓର କାଉନସିଲ ଫାଇଲ କରିଥିଲେ, ତାରିଖ କେତେ?
+37
ଆଜ୍ଞା
37
3/7 ରେ ଫାଇଲ କରିଛୁ।
ଆଜ୍ଞା
ଆଜି ହଉଛି କେତେ? ଆଚ୍ଛା
5
ଥ୍ୟାଙ୍କ ୟୁ।
6.
This order କରାଯିବ ତମେ। Other side ବିଭୂତି ଭୂଷଣ ବେହେରା, when it reaches the order will be passed, okay? ଆଉ ଯୋଉଟା ଫାଇଲ କରିନାହାନ୍ତି ରିସିଡେଣ୍ଟ କା ରେଜିଷ୍ଟ୍ରି ଫାଇଲ କରିଦିଅ। କପି ଦରକାର ନାହିଁ ସାର୍। It is already mentioned and you whatever saying is believed, no difficulty. But ଆପଣ ଯଦି ଫାଇଲ କରିନାହାନ୍ତି ସେଟା ତ ରେକର୍ଡ କୁ ଆସିବନି ନା। Yes. Yes, next.
Page 3, 19 to 25.
item 20 minutes
Yes.
or for Mr. Millers.
ମେମୋ ଦଉଛନ୍ତି
ଆଜ୍ଞା
ତାର ପେପର ଦିଅ, କିଛି ପେ ଦେଇଛନ୍ତି। ଠିକ ଅଛି, ଅର୍ଡର ୱିଲ୍ ବି ପାସ୍। ଅଦର ସାଇଡ୍ ଆପିୟର କରିନାହାନ୍ତି।
ନାଇଁ
ଠିକ ଅଛି, ଅର୍ଡର ୱିଲ୍ ବି ପାସ୍ when it reaches.
Millers.
But I'll record the earlier orders also. Okay.
Millers.
Page 21 to 25.
Then item 21 na page. Item 21 to 25. 24.
Page 4.
My lord, I love 24.
24, sir.
My lord. I'm from OP. Actually,
You are for the OP.
yeah, my lord.
So what do you want, sir?
My lord, my senior is in out of station, so I just seeking an adjournment.
Petitioner ka absence se kemti apan nebe. You have to intimate the. I'm not sitting here to start ex parte hearings. Please appreciate or pass ex parte orders. Either you inform the other side or because he comes from Bhubaneswar also. Did you talk to him?
Sorry, sir.
Please talk to him. ଗୋଟେ ଡେଟ୍ କରିଥାନ୍ତୁ ଦେଖିବା କଣ ହଉଛି।
My lord.
ଆପଣଙ୍କ ନାଁ ସାର୍?
Sriakant Patnaik.
ଏସ୍ ପଟ୍ଟନାୟକ have power here.
Yes, my lord.
ଶ୍ରେୟକାନ୍ତ
My lord.
ଡେଟ୍ କରିଥାନ୍ତୁ ଦେଖିବା।
We consent
Published.
3 yard.
But subject to their appearance and approval. ଦେଖିବା କଣ। Sorry. Yes, next.
Page 5, page 4, 26 to 33.
My lord,
31. University. It was Swapnil Roy, 41. Simply adjourn କରିଦେଲେ ହବ। Other side university ପାଇଁ ଅଛନ୍ତି କିଏ? You are there?
2, 3.
Along with Mr. Sodangi?
I am Alityapati, Venugopal Mahapati.
Okay, so Baba. ठीक ଅଛି। 31 state तो लेका इसी के adjourn
yes.
date कर दियो।
We consent the
Interim
order.
order, I am not touching. Interim order was for adjournment or a stay order? Status quo remains untouched. Yes, 31 date କରନ୍ତୁ।
We consent the order.
10/8 विक्री ଆସିବ।
Item 32.
Before filing, you serve the copy. Wait.
Item 32 million.
Yes, sir.
Alpha 4 is timing and counter. I have taken consent bill.
So Mahanti is not there.
I have consented.
So Mahanti is a tough lawyer.
Yesterday he telephoned me that yes, what do you want?
So that is how he has convinced you. 30 today we date cut.
We consent the order.
Item 28.
28, sir.
Prefer item state have to file counter.
Date cut. 28 candidate note. Mr.
We
Lekha,
consent the order.
counter question file. The noting is also there. Again, 10/8.
Aye.
32 टा कौन कले?
32 we come in those.
That's right. Yes, next.
Page 5, 34 to 40.
Item 39 mal.
Yes.
Two to file.
39 का डेट कर देवे.
Who comes in those at?
40 also mal.
208 है Mr. Tripathi.
Yes, madam. 40 also.
40 also.
RCB entry order to be
40
continued.
entry order if there is a stay or status quo, no, it's not altered actually. Simply posted in that becomes easier and that saves time. 40 your Vokalatnama has not been filed, Mr.
We shall file it.
Okay. But the next date, because
Who comes in those at?
Okay.
yes. इस जगह 208 इसलिए.
Item 1,
पासवर्ड कर देना कौन? पर्सनल पासवर्ड.
item 2,
Yes. You are Mr. Parikh. Mr. Parikh for the petitioner. Opposite party.
My lord, several times the director of the petitioner not paying the in maintenance. Only
So
adjournment.
you have to file execution. Because this court is not the executing court of the trial court or the family court or the magistrate. Yes, Mr. Parikh. What you are saying? आपन का नाम कौन मैडम?
RB Rao.
Okay, Mr. S.K. Parikh for the petitioner. Ms. R.B. Vidat Raut for the opposite party. Yes, what do you want, Mr. Parikh? कौन काहे माने तांकर एटा से कौन दरकार जो सकाळ वर्ष होला काहे नाम डाकिबे माने एफिडेविट इफेक्टेड बाय रेट्स काली आवरी वर्ष आज सेते काली रहले कोन माने काली को आगे आवरी वर्ष होला पानी भर्ती गला आवाज पहुंची परिबेनी
ନାଇଁ ରାଜନୀତିକୁ ଆସିଲେନି
टंकाटा तापर आसीयो ना कोन एफिडेविट दवा पे तो पॉइंट सिक्योर करे पे पॉइंट एफिडेविट देले कोन सिक्योर करछन It is submitted by the learned counsel for the petitioner. Further further adjournment is sought for by the learned counsel for the petitioner to comply with the order. Comply with paragraph 6 of the order dated सात 4/2026. But it is submitted by the counsel for the opposite party that the petitioner goes on adjourning the matter without paying any amount as directed towards maintenance by the learned judge family court in criminal proceeding number 20 of 2024. Stop. To grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing
13/7.
13/7. But upon you have to execute the order. Okay. Yes.
Item 4,
तो तापर सेठी प्ली नेबे जे जेतु जाइथिले कटक वर्षा रे फेरी पारलेनी एग्जीक्यूटिव कोर्ट इनटू द सागा गोज ऑन. Yes.
Hey, prisoners.
Yes, please.
Let's say the present
May say
petition.
Subhadrashini
Let's
for the petitioner. Yes.
let's say the present petition has been filed for seeking for the transfer from Raulkela to from Angul to Raulkela.
Yes.
The distance between Angul and Raulkela is
12 cannot be transferred, madam. Section 12 application cannot be transferred. Look at the provision. There is section 12 PV Act or judgment order order. The petitioner husband which is before this court seeking transfer of the application filed by the opposite party wife. ଆପଣ ଏଟା ଚାହୁଁଛନ୍ତି ଏଟା କିଏ ଫାଇଲ କରିଛନ୍ତି Pradeep
Husband.
Kumar. No, Siddhartha Kumar. Filed by the opposite party wife under section 12 of the Protection of Women from Domestic Violence Act 2005. Upper Cedar Court Kardam. The allotted counsel for the petitioner has adjournment to address on the legal issues as noted above. The matter shall be listed for fresh admission in the week commencing.
Odisha.
Odisha. 12 ray padichandi. Did you read the statute yesterday? Read. Develop a habit of reading. That's a very simple habit, but it helps and helps you grow as a lawyer also. Because whole horizon expands. You understand what you are arguing. Yes, next please.
Item 5,
You are Mr. Sahoo. Rajesh.
Yes.
Mr. Rajesh Ranjan Sahoo for the petitioner. Yes, what do you want, sir?
For hearing this revision, the petitioner husband has challenged the maintenance order passed by the learned judge family court Dhanganal Miller. But the
Grounds?
No, on the ground that the wife claimed Miller for the monthly maintenance of rupees 50,000 and 25,000 of litigation expenses Miller. The learned trial court allowed to the extent 25,000 of the monthly maintenance and Miller 18,000 for the wife and 8,000 for the minor son Miller. Now the husband is all along ready. In fact, in the learned trial court, he
Readiness
to take
readiness to take any case law or any provision.
now
Argue law, sir.
yes,
Don't argue common sense.
yes.
Any provision. Readiness to take.
Now this is a matrimonial dispute.
Sir, don't explain me, sir. I'm not your student.
Yes.
You are arguing a revision.
Sorry, Miller.
Readiness by the husband who will entitled not to pay maintenance.
No, Miller.
Any case law on that?
Now Miller,
Let us not waste time. Please be considerate about the board and
yes,
because I can't take such a view that readiness of the husband results in lack of maintenance for the wife and child. Any have you read it or you are just fabricating it?
No, Miller.
Have you read it?
Yes.
That's cite which provision? Readiness on part of the husband.
No. What I try to submit.
Sir, don't try, sir. It is not a law is not a field for experimentation.
No.
That is basic research.
Yes.
You are a student of which subject? You have been apart from being law,
I'm a student of science, Miller.
science.
Yes.
Which subject?
Zoology honors.
Zoology.
Zoology.
Geo or Geo?
Zoo.
Zoology, not zoology, zoology.
Yes.
So there you have your experiment. Did you make any dissections?
Yes.
So which were the successful dissection you made?
Frog.
Frog what?
The dissection of frog, Miller.
You dissected for what? It's just like the way you are studying law. You must have found out something. What?
Miller, the composition of heart and the blood vessels, Miller.
The circulatory system.
Yes, Miller.
Here there is no experimentation. Don't apply zoology here.
No,
So don't try to experiment what you are trying to, as you are saying that you are trying to say. So this proposition you cannot, this is not experimental field.
Yes.
There is stare decisis. What is stare decisis?
Pardon, Miller.
Stare decisis we pouchanti. I think it is pronounced as stare decisis. Either you have a provision of law because you are not requesting or begging anything. You are fighting for somebody's right.
Yes.
So how do you get that? By looking at the provision of law, any citation.
Now, Miller, the finding.
So your readiness will result for not granting maintenance.
Yes.
So which is that provision?
Now, Miller, I am not on the point that
You have said so. You want a review of this? You are forgetting what you have said.
The observation made by the learned judge family court in the judgment that I am here before this honorable court challenging
Let
that.
us not beat around the bush. You have a point to argue.
Then
What is the best point you have?
my
Readiness, first point. Second point,
readiness, so far as the income of the petitioner is concerned and the quantum allowed by the learned trial court is beyond the
for revision, like you have dissected, you don't remember for what circulator study. That's say like so. So what is the principle of revision here? You are re-arguing or the matter what was there before the trial court has to be considered.
the way the learned trial
So
court.
show your pleadings. So what was your pleadings in the written statement? Don't use your speed.
Yes, ma'am.
What is your stand? And what is the finding on that?
Yes, my lord. Now, kindly have a glance to page 21, para 7, my lord.
Yes.
Here is my answer, reply to the allegations made by the wife.
Now, so show your deposition then. પણ એથી prepare લાવવાની sir.
No, my lord.
ଆପଣ ଏଠି ବି ଆପଣ ଫଟଫଟ କହିବେ ନା.
Yes, my lord.
The speed at least, what speed I am maintaining, at least you should be half the speed. Not you will start searching. It is submitted by the learned counsel. Straight away come to the point, sir. Why you are
Kindly have a
searching?
glance to para 7, my lord, for once. Here, my lord, the petitioner submitted para 7, my lord. That the allegation, shall I read, my lord?
You need not read, sir. What is your point? I am not asking you to read anything.
Yes.
What are your stand apart from that? Your readiness to take them.
Yes.
Then what are your stand to deny maintenance? What is the second best point?
But my second best point is that so far as the quantum is concerned, the petitioner will independently income something from other sources.
Which case law? If the petitioner is capable of earning, which is the case law on that?
Now, my lord,
That the court will deny her maintenance.
the Rajneesh versus Neha, my lord, categorically clarified that even if
Which paragraph? Don't guess it. Don't guess a Supreme Court judgment.
yes,
It's a very bad thing that in public view you are guessing a Supreme Court judgment. So which paragraph of Rajneesh versus Neha?
with that judgment currently,
So that can't be any, apart from being current, there can't be any past on that. Are you invited to speak on Rajneesh versus Neha extempore?
I am entirely.
Did you read any case law during a student?
Yes, my lord.
Which is the best case law you read in family law? Which you remember which had impact on your mind?
In my student time, my lord,
Yes.
that my lord.
Anyway,
I am on.
sir, don't
on
never take a chance that Rajneesh versus Neha, which paragraph, what you are submitting. Yes. So since she is capable of earning, she is not entitled to maintenance. Second point. What is the third point?
My first point, my lord, is the voluntary desertion. Second point is
Voluntary desertion, can the court enter in 125?
no.
So how you have proved voluntary desertion in your examination in chief?
No, my lord.
Did you examine yourself?
Yes, my lord. No, though I have not the certified copies.
Certified copy, no.
Yes, my lord.
Have you prepared that way?
Yes, my lord. My lord, kind of have a glance to the judgment.
Not judgment. Yours. Whether you examined yourself.
Yes.
That she has voluntarily, or you asked her.
Yes, my lord.
Yes. So what was your answer? Now you better sit and read. Let me dictate down. The petitioner, husband is before this court challenging the order dated. Ajal, when you found what was the question put by you?
Yes.
While you cross-examined your wife.
Yes.
Regarding voluntary desertion, tell me. Sit down. Mr. Appearance Dakit. Mr. Rajesh Ranjan Sahoo for the petitioner. The petitioner husband in the marriage is before this court challenging the judgment dated 28/3/2026 passed in CRP number 73 of 2024 by the Learned Judge Family Court Canada. The said petition was filed by the wife in the marriage and toddler child, is it about 2 years, seeking monthly maintenance at the rate of 50,000 per month for both mother and child, and 25,000 as one-time litigation expenses. Para. The petition was favored, however, granting an amount of rupees 18,000 per month to the petitioner number 1 and rupees 8,000 per month to the petitioner number 2 child. Petitioner number 1, that's wife, and 8,000 to the petitioner number 2 wife. Seeking the revision, it is argued by the learned counsel for the petitioner that the petitioner is willing to take the wife and child. Therefore, they could not have been granted monthly maintenance. The second argument is the wife is capable of earning. Therefore, she is not entitled to any maintenance to be paid by the husband, wife and child. Since the wife is capable of earning, the wife and child are not entitled to receive any maintenance from the husband. The third argument is the petitioner, the wife, the opposite party wife voluntarily deserted the petitioner. Stop. The learned counsel for the petitioner is apprised of the provisions of law in section 125 CRPC. The essential ingredient being the wife 125 since substituted and since repealed and substituted by 44. That the section 125 the council is apprised of the provision 125 CRPC. Ingredient being, if any person having sufficient means neglects or refuses to maintain his wife or child, and the magistrate and the concerned magistrate into bracket judge, family court, cannot enter into a dispute regarding desertion or otherwise by any of the parties, which has to be proved in the appropriate proceeding. The scope and interpretation of section 125 CRPC has been elaborately dealt with by the Honorable Apex Court in Samima Faruqi versus Sahid Khan, to answer one citation, followed and reiterated in Rajnesh versus Neha. The learned counsel for the petitioner is apprised of paragraphs which deal with the contentions raised that if the petitioner is capable of earning, the petitioner wife is capable of earning, then what would be the approach of the court? Since it has been authoritatively laid down by the Honorable Apex Court in Samima Faruqi regarding the scope of entertaining revision and the power of revision to be how the power of revision to be exercised at paragraph 20, the said paragraph is reproduced here. Following Samima Faruqi, Supra, the learned counsel for the petitioner was requested to place whether the allegations made in the allegations were made in the written statement filed before the learned trial court, and whether the claimant wife, the petitioner wife before the trial court was examined. He6 and has adjournment. The matter shall be listed for fresh admission in the week commencing 27/20/24. Pile?
Yes, ma'am.
Question ko pachale.
In my suggestion,
Are question da padon to mafta explain karon to. This particulars.
yes, ma'am. No, para 38 of the crossing.
ठीक है सर, वो पचल तो
Yes.
कौन पचल
The council put a question.
ଲେଖା ହେଇଛି ସେଥିରେ council put a question.
Like,
Always be precise.
Yes.
Straight away go to the question. କଣ ପଚାରିଲେ?
the question is not there, but the answer says the opposite party answers me, Lord. I am no more agreeable to stay with the opposite party, as I am apprehensive about my life and as I was subjected to torture earlier.
That
Therefore,
I wanted from you.
No.
So which court will direct? You must understand the law.
Yes.
Your allegation of voluntary desertion is completely negated by the torture and cruelty.
No, my lord. My lord, the earlier paragraph.
No, my lord, ମାନେ କଣ? No, my lord କଣ ସେଟା? Are you an agent or a lawyer?
No, my lord.
You are a lawyer?
Yes, my lord.
So once the wife takes the plea of torture and cruelty, which court will ask her to go there?
But that,
Please appreciate you are a lawyer.
yes,
You
my lord.
must understand and read law. It is submitted by the learned counsel for the petitioner that in response to the cross-examination, the question put by the on behalf of the petitioner husband, that the wife, ପଢନ୍ତୁ ସେ,
Aye.
the wife stated before the trial court in evidence, before the learned judge family court in evidence, ପଢନ୍ତୁ.
I am no more agreeable
I am no more agreeable to
stay with the opposite party,
stay with the opposite party as I am apprehensive about my life
and as I was subjected to torture earlier.
and as I was subjected to torture
Earlier.
Huh?
Earlier.
Torture earlier. You should not have asked this question. The trial court counsel should not have asked this question.
Yes, my lord.
Because you are chopping off the branch where you are sitting.
Yes.
You have to be very careful.
Yes, my lord.
That is how, when I asked you that, did you read any case law on this?
Yes, my lord.
The always standard defense for any lawyer, because you see, any lawyer worth his salt will argue the matter.
Yes.
Even if she is not tortured, let us assume.
Yes.
The lawyer will take the stance, he will be trained for that question.
Yes.
So no court will allow. In fact, because this honest judge family court is at times they are the senior most.
Yes.
Anyway. I would like to add in view of the law laid down, in view of the Lord Counsel for the petitioner is apprised of the provisions contained in CPC Order 41, 3-1, 3 capital A, 10, and 11. Order 31 rules करने. अपन सेटा पूरा टाइप कर चुन जोड़ा. तापर पूरा reproduction. Yes, next.
Item 6.
So Saubhagya Swami for the petitioner.
Petitioner seeks to transfer of execution case filed before the first additional MSCD court Jagatsinghpur to the Bhubaneswar Milord.
Who has filed execution?
I have filed the petition with
How can you yourself filed and why you want to transfer?
because
Because the difficulty is that the case was decided at which place?
Jagatsinghpur.
Then how can it be transferred? Execution will be frustrated.
Because
The strategy of the petitioner executing a decree cannot be that it will frustrate the execution.
it is difficult for her to move from Bhubaneswar to Jagatsinghpur to proceed the case.
For execution, movement is not necessary. Prosecuting the execution is necessary. Like she has come to High Court, engaged you. She will engage a lawyer in to Jagatsinghpur.
Yes, she has engaged.
Yes, that's it.
Will not see.
You cannot, simultaneously file execution and seek transfer to another place.
She has filed 2 dates has been there.
And check the provision of execution.
The discussion of the court to consider whether it is inconvenience for the party or not.
Where it is execution? Execution, transfer.
Section 24 CPC.
24 is application. 24 achi execution.
No, sorry, execution. That's
So read execution first.
Order 21, Rule 11 CPC.
अच्छी बही अच्छी ना देवी
Oh, yeah.
बही दो को ग्राउंड रे एग्जीक्यूशन नहीं पारी अन्य जगह रे
When the property is situated in the other
अरे
court,
I don't want a speech from you, sir. Only student, I am a student of law. You have to train, educate me in law. Order 21, yes.
Order 21, Rule 11.
Hmm.
Where a decrease for the payment of money, the court
Four,
may
look at 4 and 5. Order 4 and order 5. 4, 5, 6.
transport to court of small causes.
Hmm.
Where a decree has been passed in a suit for which the value of set forth in the plaint did not exceed 2,000 rupees and which, as regards its subject matter, is not expected by the law for the time being in force for the cognizance of either of the presidency or a provincial court or small causes. And the court which passed it wishes to be executed in Calcutta, Madras, or Bombay.
So leave it there. So there is a provision for transfer in case 2. Then 5.
Mode of transfer. Where a decree is to send for execution to another court, the court which passed such decree shall send the decree directly to such other court, whether or not such other court is situated in the same state. But the court to which the decree is sent for execution shall, if it has no jurisdiction to execute the decree, send it to the court have such jurisdiction.
So now read 24.
Process for execution. When a preliminary measures, if any required by foregoing rules have been taken, the court
Section
shall.
24 देखो.
Your Lordship.
Section 24 देखो तो. Section 24.
Yes. General power of transfer and withdrawal. On the application of any of the parties.
आपण रोमन A B रे सीधा पढ़ांतो. A B सेटा समझ लो.
Transfer any suit, appeal, other proceeding pending before it for trial or disposal of any court.
So execution टा कौन आवा? Any suit, appeal, other proceeding?
Other proceeding.
Could be, possible. B. Other
Withdraw of
proceeding?
any suit, appeal, or proceeding pending in any.
But how do you read 24 which has specific provision of transfer? Order 21.
In that,
So there is a possibility that the property is situated at another court, it can be transferred. Otherwise, that court cannot be conferred with jurisdiction.
confirm.
Yes. Section 24 is that for transfer of suit.
Suit, appeal, or other proceeding.
Exactly. Other proceeding, if you are saying that it is a execution, then how 24 will be read? Order 21 will be read.
Order 20 contract.
How order 21 will read? Will be read. Order 21 transfer of court to some where the own decree shall be executed by another court.
Another.
Then how do you read to 21(6)? So you have to make prayer before that court for any property which is situated in Cuttack, possibly. I don't know whether that is a problem. Why this execution becomes difficult if you transfer it? Because original court will transfer it to another court where the property is situated. And it will say that you execute the thing. But if it cannot be transferred by High Court, where there is no property.
No, property is not there. Only claim is there. Property.
Whatever. Upon execution na jo property ho, claim ho, upon office seize karibe ki gadi seize. Tankar kon property hote seize haba. That may be immovable or immovable. Execution result kon haba. Failure to execute is. So execution cannot be transferred. Should not be transferred. Rather, it will frustrate the execution.
You not see insurance company to pay the claim amount.
So they'll pay it in Jagat Singhpur because the cases of Jagat Singhpur.
Yes, Jagat Singhpur.
You have to do some research if you want that, because you are arguing a very complex point of law that it should be transferred from the trial court to another court by exercising power of 24. So that you have to find out some case law on that.
Yes, sir.
I had ordered counsel for the petitioner at some length. The petitioner being the decree holder in MSCT, case number 32 of 2021, decided by judgment dated 27/9/2024. She has filed the execution petition for execution of the said decree. Then data into colon motor accident claim execution case number 95 of 2026 pending before the District Judge DASCOM Fast Motor Accident Claims Tribunal, Jagatsinghpur. By filing this present application, the petitioner seeks to transfer her execution case filed before the court that had passed the decree, judgment and decree, and proceeding with the execution to the court, to an court at Kotak, but to an court at Bhubaneswar. Learned counsel for the petitioner is apprised of the provisions contained in Order 21 of the CPC that deals with execution of decrees and orders and payment on the decree. The learned counsel for the petitioner relies on Section 24 of CPC seeking transfer of the execution as well, referring to the word any proceeding portents. The learned counsel for the petitioner has adjournment whether by transferring the execution pending before the executing court that had granted decree, the decree can be effectively executed at the new place where she seeks to be transferred. New place, no, to the court of to the new court. Yes. Matter shall be listed for fresh admission in the week commencing.
27.
27. Yes, please.
Item 8,
So Niranjan Prasad Patra for the petitioner, opposite party black.
I am challenging the order dated 7/11/2025 passed by Judge Family Court. Family Court, Bhubaneswar. In IN number 50 of 2012.
Yeah.
So, granting maintenance of rupees 5,000 per month. The income of the husband.
आपको read ना RPFM होगा, मतलब revisable order होगा.
ना इटा interim maintenance order है Mr. Master.
Interim maintenance in section कितने?
Section 24.
Section 24.
ଆଉ ଗୋଟେ କେସରେ ବି ଆମେ ମାନେ RPFM କରିଦେଇଥିଲୁ ସେଟା ଡିଫେକ୍ଟ ହେଲା ତ ଏ କେସରେ ବି
and it is a single judge matter.
It is single judge
because family court division bench, but you are saying that it is interim
it is a single
matter,
judge. It is single judge.
Not honored counsel for the petitioner wife in the marriage is before this court, challenging the order directing payment of interim maintenance at the rate of rupees 5,000 per month, seeking enhancement of the same. Stop. The date takili. पढ़ो तो. Order जो लिख लिया, order dated 7/11/2025. Directing interim maintenance. Order dated directing payment of interim maintenance by the wife in the marriage. By the husband in the marriage. So it's wife na husband किए mention.
Wife enhancement.
Magition भी husband ना वो function भी wife. Maintenance किए मागिले, wife मागिले ना.
Wife मागिले the Laurent.
Husband in the marriage na. Same. The order dated 7/11/2025 filed was passed in the IA number 50 of 2025, arising out of CP number 829 of 2023. Arising out of CP number 829 of 2023, जो IA लिखे नहीं, the IA number 50/2025 has been filed under section 24 of the Hindu Marriage Act, seeking maintenance pendentalite, arises out of CP number 829 of 2023. The CP has been filed by the husband in the marriage. Na apna file karcho
नहीं से फाइल
under section
Hmm.
13.
13
Section 13 of the Hindu Marriage Act, 13 into bracket 1 into bracket I-A, Roman 1 dash small a of the Hindu Marriage Act, seeking dissolution of marriage solemnized between the parties on 10 July 2022 and grant of decree of divorce. You should notice along with this order. So notice into the issue notice the opposite party. By speed post with registration and proof of delivery. Returnable date be fixed to
10/8.
10/8. The matter shall be listed in the week commencing 10/8. Requisites be filed within
3 days.
within 3 working days. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. Returnable date be fixed to 10/8. The matter shall be listed for orders in the week commencing 17/8/2026.
17
Para. It is further directed that the petitioner shall continue to receive the amount of maintenance directed by the Lord Judge Family Court in so and so, without prejudice to her rights and contentions based in the present application. Yes, next.
Item 9.
May I please about? Yes. So Niranjan Lekha for the petitioner.
OP1.
GM Lekha, additional government advocate.
OP1.
OP number 1.
Pursuant to the order dated 12th of March, I am submitting the affidavit.
Just saw a copy.
Yes, yes. Copy sought.
So we can take it up another day. If you are serving it today,
Yes.
the London, it about registry file कर दियो. Let it be uploaded out.
I pray for a short date because.
Correct. The petitioner, कितने number item है?
9.
9. The Learned Counsel for the petitioners refers to the earlier order dated 12/3/2026
Yes, ma'am.
and the subsequent order dated 10/4/2026 and 11/5/2026 and submits that affidavit is being filed on behalf of the petitioner. Further affidavit on behalf of the petitioner, giving the details as noted in the order dated 12/3/2026, paragraph 4. Copy of the affidavit has been served on the Learned AG.
Yes, ma'am.
Learned AG. Affidavit shall be filed in the registry during course of the day. Scanned copy be updated. ଏଟା କେବେ ଆଣିପାରିବେ ଆପଣ?
15
ଆଜି କେତେ ତାରିଖ ଅଛି?
6.
15 ହେଲେ ଚଳିବ ନା ଆହୁରି ଆଗରୁ ଚାହୁଁଛ?
ଆଉ ଟିକେ ପ୍ରୋବ୍ଲେମ ହଉଛି notice ଟା
The
ଯାଇ
matter shall be listed on for fresh admission.
15 ଅଛି।
15 ଆସିଲେ ବି ହବ?
ହଁ 15
ଠିକ ଅଛି। ଆପଣ ତାହେଲେ with the week commencing 13/7 କରିଦଉଛି। ସେମିତି ଆପଣ ଆଡଜଷ୍ଟ କରିବେ। ସେ 13 ରୁ 15 ଭିତରେ ଆଡଜଷ୍ଟ କରିଦେବେ। ଠିକ ଅଛି। Yes, next.
Item 11.
So Brajkishore Panda for the petitioner.
Madam.
Opposite party blank.
Limited grievance measure. The petitioner seeks for a direction from the Hon'Ble Court to the Learned Judge Family Court, Bhadrak, for the early dispatch of CP number 40820.
Sir, now that is governed by which decision of the Supreme Court? Early disposal orders to be passed by the High Court. is governed by which decision of the Supreme Court? What is the bench strength? There is a constitution bench decision in Allahabad Bar Association. The Supreme Court has said that such orders cannot be passed. What is the ground you are seeking early disposal?
The ground is speedy trial is the right of the accused, which has been guaranteed by the
Accused.
by the petitioner. The case, the fact of the case is that, my lord,
You have to read those cases. So both of them, Mr. The petitioner is the only that is the only case pending.
my lord,
Only case pending before Bhadrak. Have you filed that affidavit? There is no other case pending before Bhadrak court.
on petition has filed this divorce case.
Oh. Petitioner is the only litigant there in that court, or other litigants are there?
In this CP,
Not CP. How many CPs are pending? That is the Supreme Court has pointed out. That since somebody should not come to a constitutional court and seek a direction because I should be granted. What about the other litigants? Those who have not come, or those who choose not to come? Can they be discriminated?
the petition has filed this petition for dissolution of marriage.
Sir, that is what petition CP is filed. I am not asking. So, is there any other case pending between other two parties, other litigants there in that court, or this is the only case the court is handling? Anyway, disposed of. So, I am just issuing a direction that
Stipulated
yes.
period.
No stipulated. You have to read, but your lack of preparation is apparent. And I will be again wasting time in apprising you the constitutional bench, the subsequent decision. Even in cases of speedy trial, the Honorable Justice Oak has observed the High Court should not do what it is every day doing. Because a person who is a right of speedy trial is every person, not one person who comes to High Court. For that reason, the Supreme Court has said that we should not interfere.
Well, in this case,
पूर्व केस जदि किछि पेंडिंग नाही एफिडेविट देबे ताले कोन हे परियो
the wife is neither attending the court nor
correct when the opposite party does not attend, what is the provision in CPC?
and thereafter he was set expired.
Thereafter kono mo, what is the provision in CPC thereafter? Did you file any application? आपण जो केस रे आपण जोतिर वाइफाई अपेयर करछन्ती आपण भी अपेयर करू नांती
No, sir, I filed the
that
entire
happens
order
for every
slip.
lawyer
I filed
online route 13 फाइल ହେଲା तापर एक्सपर्ट ହେଲା पर कोन ହେଲା
thereafter he is getting maintenance under section 24 of the Hindi Marriage Act. Thereafter, my lord, neither he is attending the court nor cooperating with the proceeding.
exactly sir
Only he is filing only Hajira and time fixer.
पछू जाउछन्ती
Aye.
neither she is attending the court not cooperating.
My lord,
So what thereafter have you filed any petition?
I filed the my lord, kindly see the certified copy. I have the-
अरे kindly नुह मु कोन अनकाइंड भला लागुची आपण पचारु तो सेति पई
My lord.
did you file an application?
Now the case is pending for further cross examination.
And what
He is not coming, and so that is the
so
procedure.
it is an appropriate application.
My-
When the petitioner approaches, the plaintiff appears and the defendant does not appear.
My-
There is elaborate provision in CPC. You have to follow that. ठीक अछि से आदि डिस्पोजल ऑर्डर अछि बुझी देबे बोलो disposed of. Yes, next.
Item 12,
May I please your lordship?
Shivani Shankar Pradhan for the petitioner. Opposite party blank. Yes, Mr. Pradhan.
My lord, similar prayer to previous my lord item. Lordship may pass.
Early disposal. Early
My
disposal.
lord, my lord,
Disposal. Same one. Yes.
my obligation.
Yes.
13,
पास ओवर करथा तो मन देखिवा
15,
lost validity.
15 day.
Yes, sir.
Mr. Prasanto Kumar Mahali for the petitioner.
I pray only one thing, my lord.
Mr. ଆପଣ କଣ ଆଗରୁ appear କରୁନଥିଲେ?
ମୁଁ କରିଥିଲି ଆଗରୁ ମୋ ନାଁ ବି ଥିଲା କିନ୍ତୁ ସେ କାଇଁ ଆସିନି ଜଣା ପଡୁନି
ଆଚ୍ଛା
ଆଉ ଗୋଟେ
ଏଇଟା କଣ ଆଇଏ ଗୋଟେ ଫାଇଲ ହେଇଛି?
ଆଜ୍ଞା
आईएटा सर कोन पई कहले
आइटा पैसा डिपोजिट करना इंस्पेक्टर ऑर्डर पास बाय दिस ऑनरेबल कोर्ट
पैसा हे नतला एबे हेची कोचो
आज्ञा
एबे डिपॉजिट हेची बोली
एबे डिपोजिट बोली एबे कोर्ट
अच्छा ठीक अछि आईए 134 आईए 1324 ऑफ 26
आई विल लॉर्डशिप 1 मिनट ए से पैसा
अरे
डिपोजिट
मुझे ऑर्डर टा तो फिर करे पड़िबो ना आपण मान जो जनरल डिस्कशन मते भी भल लागे बट स्टिल देन आई हैव टू मैनेज माय टाइम आल्सो आई एम नॉट ऑब्जर्विंग एनीथिंग अगेंस्ट यू और हिम both of I know very I mean tough counsel
नहीं मुझे मुकल्ली से
बट मते तो फेरे ऑर्डर शीट लिखिया पड़िबो जे आपनकर गोटे पिकुलियर आपण जो केस फाइल हेची तो फिर डाकी भी त सी कोन करिवो मिस्टर प्रशांत कुमार महली फॉर द पिटिशनर आईए लिखो तो आईए 1324 ऑफ 2026 ए आईएटा आपण फाइल करछन
आज्ञा
The IE in the disposed of case has been filed by the सेथरे आपण थिले opposite party respondent थिले
रेस्पोंड
इटे MSC डा कोन सिंगल बेंच
एमएसए सिंगल
कोन देखले the respondent in the MSC IE 1324 Mr Naik 1324 ठीक अछि त आपण का आईएटा जोटा फाइल करछन
132
अच्छा 1324 with the following prayer It is submitted by appearance में लिखियो पड़ो आइए लिखियो ऊपर arising out of MSC एते disposed of ने एटा MSC टा पेंडिंग ने सीक्वेंस में ताको देखो ना कॉस्ट टाइटल पूरा ऊपर से लिख देले आइए जो लिखचोंती लिखिबे पिटिशनर रेस्पोंडेंट मिस्टर पवित्र कुमार नायक हैला opposite party respondent Mr. Prashant Kumar Mahal the IE has been filed by so and so it is submitted by the learned counsel for the respondent petitioner that the IE has been filed as the order dated 11/2/2023 dispose of ହେଇଗଲା ସେଦିନ 11/2/23 order ଟା
लोक अदालत डिस्पोज ऑफ
order dated 11/2/2023 passed by the Lok Adalat in MSCA number 281 of 2022 the national Lok Adalat passed by the first national Lok Adalat MSCA number ete of MSCA no 281 of 2022 was not complied with regarding deposit of the amount of 5,86,000 go to second row deposit the amount as recorded pursuant to the disposal by the Lok Adalat. Yes, Mr. Naik. Yes, what you were saying?
He has not intimated to the court. He has today just now I got information
that I understood. I am not asking you that why you are not.
Yes, he has not intimated to the court that regarding this case he has deposited. He has deposited in NEFT in the court, my lord. But he has not intimated to the court in which case he has deposited. That is the problem, my lord.
So, Mahali, you file that. What you can do if at all that that's a simple technical error.
Only
you can file a memo.
Yes.
Let's see, directly only file.
Counsel for the respondent petitioner in the IA that the amount has been transferred to the account. को जगह से को account वाला to the account of so and so tribunal पूरा कौन तो third MSCT Raurkela by NEFT but by UTR number लिखी दे दो चला भूल भाल हो कालो क्यों by UTR number dash
for a sum of
rupees dash however since the MSCA is not referred MSCA or the should I case copy MSC case has not been referred to. The amount is still lying in the account of the Lorraine MSCT without being dispersed to the beneficiary stuff. It is submitted by the Lorraine counsel appearing for the respondent opposite party that the needful be done by filing appropriate affidavit memo affidavit do padibo na kon seti
सेठी गोटे सर मेमो दे दिबे केस में
हां सेटा का ट्रांसफर सेठी के गेला मु प्रथम हाई कोर्ट गेलो
नहीं
मु दे दी तापर आपन कोले सेठी गेला
ट्राइब्यूनल सर
गोज ऑन appropriate memorandum shall be filed before the learned MACT third MACT Raukela, indicating that the amount deposited is towards the award made in so and so, so and so. In view of the above, the IA is disposed of. It is hoped that upon filing of the memo, it is directed that upon filing of the memo by the appellant insurance company, the MACT shall do well to disburse the amount to the beneficiary by following due process. Yes, next please.
Item 16.
Yes, 16 upon
14 minutes, I just
14.
missed out.
14, yes. 14 was passed over. 14 it is to be withdrawn.
This is for withdrawal, my lord. There is one more IA, in fact, let's which is there in the brief, my lords, towards the end. One is for withdrawal, my lords.
20691.
There is
you are placing 206 pass over 10, 14 dakam. Pass over 14.
14.
Pass over kahibe na 14 kon.
Pass over 14.
Yes, my lords. Now this is for withdrawal. There are two IAs which are filed, my lord. The IA for withdrawal, my lords, is my lords 11472 of 2026.
Was there any order earlier?
There was an earlier order, my lords. According to that, I have filed an IA that is
Can you
order
place
dated
that order?
17/3/2026.
Please place that.
Yes. That's learned counsel for the matter has been listed for hearing under the heading.
Beyond that, you can state away para 3.
Para 3. Learned counsel for the petitioner refers to the earlier orders, particularly the order dated 18/7/24 and 23/2/2026, to submit that consistently the learned counsel for the OP has not been appearing. It is submitted by the counsel for the petitioner that initially the petitioner company had issued a bond issued by Citibank Delhi pursuant to the order dated so and so. The said bond has been returned by the registry of this court, and subsequently the amount was deposited in the form of a demand draft which has been invested in an interest bearing account to the Union Bank of India, Odisha State OSBC branch, and the amount is now reported to be so and so as on 16/6/23. It is submitted by the counsel for the petitioner that the petitioner has been facing difficulty in liquidating the bonds submitted earlier issued by the Citibank. He seeks certain directions. He seeks further directions in the said regard to enable the petitioner company to liquidate the bond. In considered opinion of this court, if any IA is filed by the petitioner seeking any direction on the issue as raised on behalf of the same shall be taken up and appropriate order shall be passed. The next detail of listing as well as today's order shall be communicated to the learned counsel appearing for the OP. Interim order passed earlier. In the meantime, we have settled.
Communicate question देखो noting नहीं करे. Yes, तापर कौन है?
तापरे आगे हमें से IA टा file करो. As per this direction, there is an IA which has been filed, which is the office note does not say so, but it is there in the brief, my lords. My lords brief, it is there. That IA number, if your lordship sees, in this case 20691, that IA number is IA number 7699 of 2026. That is towards the end of the.
Actually, our office note a problem. Those who are entering it, they are not understanding. So.
That was filed on.
Notice issue there a second matter, Mr. Barik, that registry is not putting up any note. But upon notice, debe tango intimate kariyo to likhiwe pare. So the prayer achi IAS, I got the IA 7699. What is the prayer?
The prayer, my lord, says, I'm just reading out. The prayer, my lord, says. Under the facts and circumstances, this honorable court may graciously be pleased to allow the application pass necessary orders directing State Bank of India, Main Branch, Parliament Street, New Delhi, to liquidate the fixed deposit bond bearing deposit number so and so and all subsequent renewals as submitted by the petitioner in the instant case, and return the principal amount of rupees 4,47,640 along with accrued interest to the petitioner, and further be pleased to pass any other order. In the meantime, my lords, we have settled it with the opposite party. Checks have been paid. That IA for withdrawal contains.
Those details where you have mentioned.
My lords.
What you are saying, in the meanwhile, we have settled with the opposite party, checks have been paid. So where it finds mentioned?
Yes, in
place of the IA.
Yes.
Or any other thing.
No, in the IA itself, I think. That is IA number 11472. Yes, I'm just reading out. Paragraph number 4.
So 7699 is earlier, then 11472.
Okay. Because this is after the, my lords, the settlement. that during the pendency of the present writ petition, parties have amicably settled the dispute wherein it has been agreed upon by the petitioner, that the petitioner will pay a lump sum consolidated amount of rupees 4,47,640 to the opposite party towards full and final settlement, after which the opposite party will have no further claim against the petitioner insurance company on the same cause of action. In this context, a copy of the email dated 28/4/2026 sent by the counsel of the OP to the authorized officer of the petitioner insurance company is annexed here with his annexure A. I've given that annexure. A copy of the account pay check dated 8/5/2026 drawn in favor of opposite party Malati Diggal, drawn on Citibank and in New Delhi bearing number so and
That
so.
check has been received by them, you have not mentioned?
That I have not mentioned, but that they have dispatched it directly.
No, not to. You have to, on oath, you have to state that. The other problem is that this has to be taken up in presence of the other side.
I had called them actually in the morning also, but the check copy also. I have.
Check copy is neither here nor there.
No, and
So Hon'Ble asked for the petition for the petitioner, opposite party blank. The earlier by order dated 17/3/2026, detailed orders were passed, noting the contentions of the petitioners and petitioner regarding the amount of rupees आरो bond टा कितने थिला? ठीक है, इसमें amount लिखा है regarding the bond issued by the Citibank Delhi pursuant to the order dated 6/11/2017. The further fact that amount of rupees 6,07,136 as on 16/6/2023 has been deposited in Union Bank of India, Odisha State Odisha State repeat ହେଇଗଲା Odisha State Bar Council branch, OSBC branch, Kacheri Road, Cuttack, has been noted. Stop. The learned council, a copy serve ହେଇଛି ତାକୁ ଉପରେ
copy I for withdrawal terminators I had brought the copies. I had already.
ଗୋଟେ କାମ କରନ୍ତୁ नहीं ଆପଣ ଆଇଟା ଖାଲି simply withdraw କରିବେ ନା amount ଗୁଡାକ ଫେର liquidate ହବ
ନା ସେଇଟା ବି liquidate ହବ. That I also need to be adjudicated upon.
better you take notice in these IAs. No way out.
See, again, see the check now. The problem now, my lords, is this check is dated 8/5/2026. Now, if that
problem is not court's problem.
No.
Court cannot be akin to a banker. Must understand whether it gets expired or gets that is inconsequential as far as legal process is concerned. IA number IA number 7699 of 2026 and IA number 11472 of 2026. The learned counsel for the petitioner has placed the prayers made in both the IAs and the purpose of filing the IAs. Issue notice in both the IAs to the opposite parties by speed force with registration and proof of delivery. Apart from taking notice, the petitioner shall have liberty to serve extra copies of the IA of the learned counsel on record. Though it was directed by the registry, though it was directed by this court at paragraph 5 of the order dated 17/3/2026 that the said order as well as the date of listing shall be intimated by the registry to the learned counsel for the opposite party. No such office note is put up whether compliance has been made or not by the registry. Stop. Accordingly, it is further directed. Copy of the order dated 17-3-2026 as well as today's order shall be served on the learned counsel for the opposite party.
He's Mr. Satpathy, my lords. His name
R.R.
R.R. Satpathy. In fact,
Mr. R.R. Satpathy.
yes.
The next date of listing shall also be intimated to the learned counsel. The matter shall be listed for orders in the week commencing.
Please.
Those
So it will expire in the month of August, first week of August. Can we have it sometime, my lords, in the week commencing 20th of July?
20 August week ରେ ଆସୁ ଏହା କହୁଛନ୍ତି
By that time, expiry ହେଇଯାଇଥିବ ସେ check ଗୁଡାକ।
ଆପଣ ଅଗଷ୍ଟ କହୁଛନ୍ତି
ଅଗଷ୍ଟ 8 ରେ expiry ହେଇଯିବ।
ମୁଁ ତ 7 ଜୁଲାଇ କହୁଛି 7 ମାନେ ଜୁଲାଇ ଆପଣ ଅଗଷ୍ଟ ନା ଜୁଲାଇ କହୁଛନ୍ତି
No, no, I'm saying, my lords, in August. Week
so
commencing.
so so we are now in July or August? We are in July.
Now in July.
Okay. 27 ରେ ତ ମୁଁ କହୁଛି
27, ହଁ।
ଏଟା ଦିଟି ଯାକ ସେକେଣ୍ଡ ଟାଇମ୍ ଏକା ଜିନିଷ
Second ଟା ବି ଏକା withdrawal. There also, my lords, checks have been.
ସେଥିରେ ବି ଆଇ କଣ କଣ ଅଛି
I have, my lords, same. The IA number is there.
ଗୋଟାକରେ ନୋଟିସ୍ ଇସ୍ୟୁ କଲେ
The withdrawal, ହଁ, ସେଥିରେ ବି I'll take notice.
ତାହେଲେ ସେକେଣ୍ଡ 20692 ରେ କୋଉ ଆଇ କୁହନ୍ତୁ
Huh, my lords, 20692, the withdrawal IA is, my lords, 11473. That is
just one second ସେମାନେ ଲେଖିବେ ନା
huh,
11473 of
2026.
20
2026.
ଆଗ ହଉଛି 7698 of 2026
769.
ତାପରେ ହଉଛି 11473 of 2026 ସେ ଇସ୍ୟୁ ନୋଟିସ୍ ଅର୍ଡର କରିଦେବେ yes next
Item 16,
Ms. P. Bastia for the petitioner.
My lord, in this case, today I have filed one IA application, my lord, for withdrawal of this case, my lord. IA number is 266, my lord.
It is submitted by the learned counsel for the petitioner that the petitioner has filed IA, which is not on record and requires consideration. The matter shall be listed in the week commencing 13/7 along with the IA. Number ta de debe.
Yes.
Listed for orders. Yes. 17. Gala. 17 ରେ the order ଦେଖିବାକୁ ପଡିବ
17,
Mr. Vidyadhara Sahoo for on behalf of S.S. Satpathy for the petitioner, Mr. Vibhuti Bhushan Behera. Sir, you are there. Vibhuti Bhushan Behera for the opposite party. The matter was presented before this court on 30/4/2024. Notices were issued by the coordinate bench on 3/5/2024. Thereafter, the opposite parties have appeared as noted by order dated 9/8/2024. ହେଲା? Memo dated 3/7/2024 has been filed by the learned counsel for the petitioner who submits that he has entered appearance by filing wakalatnama on 7/5/2024. After the petitioner obtained change and the learned counsel for the petition, the learned counsel who were appearing earlier have given consent engaging the learned counsel. Engaging Sri Sahoo. Engaging Sri Sahoo as learned counsel. Stop. The memo dated 3/7/2024 states thus. Quotates. Accordingly, the petition is dismissed as withdrawn. Copy of this order shall be forwarded to the so and so, so and so. To be kept in the records of so and so, so and so. Disposed of and so and so. Yes, next, please.
18,
Mr. A. Acharya. Mr. Acharya for the petitioner. Opposite party. Yes, please. So you want time?
No, I'm filing the memo that I made the payment.
No, affidavit. Affidavit. Memorandum doesn't help. You must understand that you are not paying.
DD has been paid.
Whatever, let him file the affidavit. You must. Talcourt order ଅଛି ତା ଦେହରେ ସେଇଟା first କହିବେ. I am filing copy of the order passed by the trial court, not memo.
No, not the memo, not the opposition. I'm filing it, so I will file it on affidavit.
Hard learned counsel for the it is submitted by the learned counsel for the petitioner referring to the order dated 21/4/2026. Paragraph 4. That some further time may be granted for compliance of the state order. Stop. The matter shall be listed for orders in the week commencing.
19,
Yes. So, Acharya, a small advice. Never trivialize anything in a court process. If you start trivializing, they will not listen or they will not respect you. And obviously, the process is not meant to be trivialized. ଆମେ ଯାହା ଚାହିଁବା କରିବା ଯଦି ତାଙ୍କର ତ impression ହେଲା, so they take you for granted. You must understand that. That is in a broader perspective, not exactly this case. I am not finding any fault. You must understand. But always try to make it simple and straight. Follow the whatever is to be done. You do that. They should not ask you जाके ମୁଁ काई फाइल करी ମୁଁ जाई पारुनी. Then case काई କରୁଛ? It is invitation दिया कि आसुन case करिवे. If they are serious, they should be serious. If they are not serious, let it be that way. तांको खुशी बा इच्छा. But let us not entertain that. That's the point I am trying to tell. Next, please.
19,
Pass over करथन देखियो.
item 20,
पुष्पा साहब मेंशन करते ना कोन?
रखा.
So Subhash Chandra Pushpalako for the petitioner. The matter being listed for orders is mentioned by the learned counsel for the petitioner. The memo of date is filed, which states thus, bracket to C click there. On 24/2/2026, after hearing the learned counsel for the petitioner, the following. कौन sentence? On 24/2/2026, the matter was heard at some length. The facts as well as the propositions of law were noted. And the following order was passed. Thereafter, on 24/3/2026, the matter was adjourned at the request of the petitioner and the following order was passed. Stop. Thereafter, on 17/4/2026, again the matter was sought to be adjourned and the following order was passed. Today, the matter being in the list, the list is mentioned at the beginning of the day's proceeding and memo of date is filed, which states thus. Stop. Para. In view of the above, the matter, the petition is dismissed. Copy of this order shall be forwarded to the learned court, learned judge, family court, dash Roman 2, Bhubaneswar, to be kept in the records of the CRL dot P dot number 131 of 2021, disposed of by judgment dated 30/7/2025. Stop. Registry shall do the forwarded by registry got the sentence. Yes. Yes, next please. Yes, next.
Item 21,
Mr. Samir Kumar Mishra, Senior Advocate, language Mr. Parta Singh.
Yes, sir. Behra.
Mr. S.R. Behra for the petitioner, Mr. H.K. Mahanta for the opposite party. Yes, Mr. Mahanta?
Here, my lord, they have not granted any maintenance to the wife. The distressed lady, there is a delay. Delay is considerable, more than 500 days. But this is a case where
125 or
this is 125, and the court says why you have not joined the company of the husband, so therefore maintenance is not granted.
judge for individual perception. Like I also think that she should join. So can I use that?
My lord, and the child has been awarded 2,000.
Both ask your senior Mr. Lenka to work out something. Okay, I'm not observing. I don't understand the difficulty faced by the lawyer also.
I am only praying delay may be condoned, your lordship, I'll give a copy.
Yes, yes. Delay by objection debe.
Objection I have already filed.
Delay ଆପଣ ସେଇ ତ cost ନେବେ ନା କଣ? ହଜବେଣ୍ଡ ଙ୍କର କଣ cost ନେବେ? ସେ ଫେର ତାଙ୍କୁ ତ ପଇସା
ନାଇଁ cost
ପଇସା ମେଣ୍ଟେନାନ୍ସ ବି ଦେଇ ବି ନାହାନ୍ତି।
I don't know whether I should
ଦେଇଛନ୍ତି ବୋଲି ଦେଇନାହାନ୍ତି ବୋଲି ମେଣ୍ଟେନାନ୍ସ ସେ ଯାଉଛନ୍ତି ତାର cost ହେଇକି ତାପରେ ଆଉ ଗୋଟେ cost।
ନାଇଁ ମୁଁ ତ
Okay.
କହିବାଟା
Our
ଠିକ
learned
ହୋଇନି
counsel
ଜାଣି।
for senior advocate for the petitioner and the learned counsel for the opposite party. এটা IA ଲେଖୁଛନ୍ତି। IA 582 of 2025. The IA has been filed seeking condonation of reported delay of 511 days in filing the revision application. It is submitted by the learned counsel for the petitioner that learned senior advocate for the petitioner that the petitioner is distressed. She is not maintained by the opposite party husband. Ground for who ground khali she is not joining the matrimony. Say ground re.
ସେ ତାଙ୍କର extramarital relationship ଅଛି ବୋଲି ଆମେ କହିଲୁ। Court says you said extramarital relationship you are unable to establish in a 125 proceeding. So you should join. Why you have not joined? You will not get.
125 ରେ ସେଟା scope नहीं तारा।
The court has said that is the reasoning, your lordship.
She is not maintained by the opposite party husband as the stop when she approached under section 125 of CRPC, her prayer has been denied. She is distressed. It is submitted that considering the education as well as the fact that the petitioner is a resident of a remote place in Odisha, there was difficulty on her part to approach this court and there has been some delay. The learned counsel for the opposite party vehemently opposes the prayer for condonation of delay. Having heard learned counsel for the petitioner as well as the opposite party, this court is this court is inclined to condone the delay in filing the revision application. The petition is favored and disposed of. The appeal revision RPFF 386 of 2025. Issue notice to the opposite party in view of appearance of the learned counsel for the opposite party. No further notice be issued. Extra copy of the petition along with all connected papers and be served on the learned counsel, Mr. Mahanta. Within 2 working days. Within 2 working days, the matter shall be listed for fresh admission in the week commencing.
Short date.
Yeah.
3-8.
Short date କହୁଛନ୍ତି 3-8 ଚଳିବ?
ନାଇଁ 3-8
3-8
ଖାଲି ମୁଁ ସେତେବେଳକୁ ଆଜି ଲର୍ଡସିପ ୱାଜ ପ୍ଲିଜ୍ ଟୁ
Request Mr. Lenka, ask Mr. Lenka that he should work out something.
In fact, with your lordship's
Next.
permission,
Yes, please.
when your lordship was saying that, do you want cost? I was wondering whether she can pay cost because
I was saying that
yesterday,
he went to the court, did not get anything.
and
Comes to High Court, court asked her to pay.
in fact,
Give him money.
if I am permitted to say, yesterday she came. And in fact, she had brought fees for me also. That is huge amount of muri, which I am unable to keep because I don't have that kind
You
of.
should have prepared mutton curry actually. Muri mansa kartha hai na.
Well, that is the property.
Yesterday I was offered muri mansa in a.
Well, that function.
Yes.
So she got a muri
Many of us had that.
That is what she thinks to be her fees to the lawyer. But anyway, that was the difficulty. Had your lordship imposed any cost for condonation, that would have been
I was asking because I always.
paid by me, not by the client.
I always have a here with Mr. Mahanta. So.
And
He's concerned what he's doing.
In 90s, I was conducting legal cases. So I enjoy also these kind of clients even today. Mate bhal lage ta case kare.
Yes.
Item 22,
Item 22, my lord, there are two RPFMs. The 418 is at the instance of the wife, my lord. Wife has,
Appear करना है Mr. Polda. Appear करना है the secondary.
No, your lordship will file the vakalatnama by the end of this week, your lordship.
Okay. अगर लिखूं तो RPFM 418 of 2025. Second is notice sufficient है on appear करना. इधर कौन order थिला appear करिया पे?
yes, your lordship.
Miss A. Das. You have received copy?
No, your lordship.
RPFM forwarded Deepti Ranjan Mahapatra for the petitioner. Miss A. Das for the opposite party.
My lord.
Submitted by Ms. Das that the Wakalatnama on duly executed Wakalatnama on behalf of the opposite party has not been received and she seeks further time to file the same. 7 days.
Your lordship, by the end of this week, so that we can appeal.
The Wakalatnama shall be filed within 7 working days. Upon filing of the Wakalatnama, the same shall be taken on record, scanned copy be updated. The learned counsel for the petitioner shall serve extra copy of the petition along with the all papers of the learned counsel for the opposite party within 3 working days, Mr. Mahapatra.
Yes.
The matter shall be listed for orders in the week commencing
27.
27 2026 along with the connected RPFM 387 of 2025. Connected लिखो 387 रे. The matter shall be listed along with the RPFM 418 of 2025 as is listed today and wherein orders have been passed on listed on date of
week commencing 27.
in the week commencing 27.
23.
After this is 23. Yes, 23.
Look at flag C, there is a petition.
So Sushant Kumar Das, senior advocate, along with Mr.
Sachin sir.
Mr.
Sachin sir.
Sahoo for the petitioner. Mr. Parthasarathi Naik
My lord,
for the
authority. OP number 1.
for OP number 1 for Mr. Anshuman Sethi for AC for OP3. It has notice any OP2.
Yes, notice sufficient and OP2 also appeared.
OP2 who is for the OP2?
But thereafter,
Authority need not be party also. Need not be hard also.
no, authority has a role, my lord. Because my lord, here, my lord,
Why you are defending your orders by appearing in court?
no, not defending, my lord. Here, my lord, the petitioner is a judgment debtor. The decree holder filed it.
Well, answer the question.
There is a fault in the part of the authority.
If I have any doubt regarding that,
No, my lord. In this case particularly,
answer the question. The learned counsel for the authority was asked spontaneously that whether authority has to appear before this court to defend its order. When the affected party has been implemented as OP number 2 and is represented. Yes, what do you say that? Why you are appearing in?
my lord, in this case, what happened? There is a mistake in the part of the authority during the certificate proceeding, not in the order. Certificate proceeding, what happened? While the authority calculated the amount which is to be recovered from the judgment debtor, authority has committed error by giving a wrong calculation.
Wrong means it has
Excess. Enhanced. Here. That part was also some amount recovered. That is also excess. When it came to notice of the authority issued letter to the judgment decree holder. Decree holder wanted to deposit that excess amount before the certificate officer. Certificate officer refused to receive because they have no separate account to keep that amount, my lord. Thereafter, the decree holder came to the authority and requested to take that amount. The authority also cannot. Authority issued letter to the present petitioner to furnish the correct
allegation.
Allegation am against କିଛି ନାହିଁ.
This is not a forum.
ତାଙ୍କ ପଇସାଟା
ଚାଲିଛି ଆଜ୍ଞା ପଞ୍ଚାୟତରେ ଯେ ଆସିବ ମୁଁ କହିବାରେ ଆସନ୍ତୁ କଣ ହେଲା ଆଜ୍ଞା ଆମେ 226 227 କୋର୍ଟ so এই ସବୁ ଜିନିଷ ଯଦି ଭୁଲଭାଲ ହେଇଛି ସେଟା ଆପଣ କେମିତି କରିବେ that we find out sir I can't find a solution for you because it looks funny to say the least. It looks funny the High Court is sitting and deciding ki adhika dela ki kam dela ka bola seta that's not the scope. I thought that there is some serious allegation against you.
No.
Then Mr. Das, now you are after you have paid the excess. Already you have paid the excess.
Yes.
It's not from my account.
They have taken away.
They have taken
certificate of
and it is admitted that they have taken the excess. So whatever is due to them by decree.
Assist if that is challenged. Because the decree, the date, the certificate is admitted.
Yes.
Amount is disputed.
Yes.
Amount is a mistake.
Yes.
Now, what is the way out? Just kindly examine and let us adjourn it to another day. If at all I can interfere. Otherwise, I cannot. I don't think.
Here,
maybe in certificate appeal.
My lord, what I am.
Certificate appeal provision.
No. What I am humbly submitting before my lord, that if some amount has been realized in excess in the process of execution, because the certificate case is almost like an execution, then it is when it is admitted also, they are also prepared to
because you have to examine the
to refund
OPDR Act. What is the provision? And in case of any wrong deduction or excess deduction, or because you see if there is a less deduction, then it is very simple that the certificate will be for the other amount.
Further amount.
The other amount which is left out.
Yes.
But if there is an excess, as the case is here, and they are fair to say that also. They are very fair to that extent.
Only when I pointed out and filed an application before this honorable court. My lord, what has happened? They are fair enough to say that the amount is to be refunded. But what they want to say that it is to be refunded to the company instead of the account from which they recovered.
No,
my submission is that wherever the amount is debited.
Your point is well taken. Said Mr. Naik, I think the simple answer would be, though oversimplified, the only it can be because you have yourself recovered from the deducted, compulsorily exacted from the
certificate officer deducted.
You have initiated.
Yes.
So now, because I think the certificate officer is also correct in saying that he can't because he is not authority to receive or to grant.
Yes, definitely. He's not.
What happened, my lord? Petitioner has furnished a wrong account number. She has got a company account number.
I'm saying that there has been a series of mistakes.
A group of companies,
series of mistakes, but the thing is that the rocket has launched and it has reached the destination.
My lord.
Suppose it would have been aborted.
Here, my lord, to simplify the issue, my humble request is, let petitioner file the correct account number by way of affidavit, and he will not dispute that. We will transfer that amount.
नहीं ଶୁଣନ୍ତୁ ଆପଣ ଯଦି ଇନକରେକ୍ଟ ଯୋଉଟା କହୁଛନ୍ତି ଆକାଉଣ୍ଟ
ସେଟା ଆଉ ଗୋଟେ ବ୍ୟାଙ୍କର ଜେଜେ କମ୍ପାନୀର ଜେଜେ ଗ୍ରୁପ ଅଫ କମ୍ପାନୀର ଗୋଟେ କାଇଣ୍ଡଲି ହାଭ୍ କ୍ଲାସ୍
ନାଇଁ ନାଇଁ ସେଟା ମୋର ବ୍ରାଞ୍ଚ କରିବା ଦରକାର ହିଁ ନାହିଁ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଭୁଲ ଆକାଉଣ୍ଟ ଦେଲେ କିଏ ଦେଲେ
ପିଟିସନର ଦେଲେ ପିଟିସନର ଯେତେବେଳେ ଚିଠି ହେଲା
କହୁଛନ୍ତି
ହଁ
so you
ତାଙ୍କ ଦିଟା କମ୍ପାନୀ ମାନେ ଦିଟା କମ୍ପାନୀ ତାଙ୍କ
become the mediator also.
My lord, this can be sorted out.
It can be.
This can be sorted out, my lord, by a simple logic. If you have debited from account number X wrongly, then where you will credit?
Just to be to go to that credit.
That account. Do that. Do that. I have given that number.
ଜେଜେ ଗ୍ରୁପ ର ଦେଇଛନ୍ତି
ଆପଣ ଡିଟେଲ କହିଲେ ସେ
my lord no
ଆପଣ ଧରନ୍ତୁ ଲେଟର
from that account we have
ଆହୁରି ଓଭର ସିମ୍ପ୍ଲିଫାଇ କରିଦିଅନ୍ତୁ ଆପଣ ସେ ଆମାଉଣ୍ଟ ଟା ମିଷ୍ଟର ସେଠିଙ୍କ ଆକାଉଣ୍ଟ ଡିଡକ୍ଟ କରିଦେଲେ ମିଷ୍ଟର ଦାସ ଇଜ ସେଇଂ ଆଜ୍ଞା ଆପଣ ଯୋଉଠି ନେଇଥିଲେ ସେଠି ଦିଅନ୍ତୁ
Debit କରୁଛ ସେଇଠି
ଚେକ୍ କରନ୍ତୁ ତ ମାନେ ଦେୟାର ଇଜ ଲିଟିଲ ବିଟ୍ ରିଫରିଂ ଦେୟାର
ରତ୍ନାବତୀ ଡେଭଲପର ର ଯୋଉ ଆକାଉଣ୍ଟ ଅଛି ଆମେ ସେଇ ଆକାଉଣ୍ଟ ରେ ଡିପୋଜିଟ କରିଦବୁ
এটা ଆପଣ
definitely
discuss Mr. Das you discuss and sort it out
yes ma'am
এটা কেবে 23 কেবে রকি
28
27
28 রে কোচ 28 উইক রে
27
27 উইক রে আসু this can be sorted out Mr. Naik
yes
what Mr. Naik has also talked to them otherwise he is very confidently saying that they have done mistake it is very unusual
no that is true my lord my limited
sort it out
my lord my submission before your lordship would
no yes I think Mr.
where
Naik,
from they have debited they have to credit in that account
I will pass that order but I will not record these things
yes.
I will pass the order that it is being discussed and it will be sorted out okay
my lord
after this
may urgent
you urgent date can find
we commission 27
पुणे sir Pranto Kumar Das for the advocate along with Mr. Chin Kumar Sahoo for the petitioner. Artharathi Naik for the P number 1. Mr. Item 23 after call कर दिया तो के OP2 appear करने के लिए.
item 23
P2 none. P3 Mr. Human Secretary Additional Standing Counsel. It is submitted by the Learned Counsel for appearing for the OP1 authority that there is an apparent mistake in recovery of the entire amount as submitted by the OP number 2 before the authority as per orders of the certificate officer. Since the amount has already been exacted from the account of the bank account, the future course of action to rectify the error is contemplated. Stop. It is submitted by the Learned Counsel for the Learned Senior Advocate that if an amount is to be refunded, it should be to the account from where the amount was taken as per the orders of the certificate officer for recovery of the certificate dues. Having heard the learned senior advocate for the petitioner and the learned counsel for the appeal number 1, this court expects that the parties shall arrive at a resolution to the issue, which is by and large is not disputed. Stop. The matter shall be listed for orders in the week commencing date केवे करते हैं? 20/7/2024. पासो ओरडा डाकी दियो.
Pasover item 1.
Your name, sir?
Satyavan Sahu. Yes, Sahu.
Mr. Satyavrat Rautray.
Yes, Sahu.
Don't have power here.
Yes, ma'am. Satyavan Sahu.
Right.
Item 1.
Item 1. I'm sorry. I'm looking at a division basis.
That's why I pray for 2 weeks time to
So
take.
Satyavan Sahu for the petitioner. The matter was passed over when it reached and when it was called and is taken up upon appearance of the learned counsel for the petitioner. The matter was presented before this court on 26/4/2025. After 1 year and 2 months, adjournment is sought for on behalf of the petitioner. To grant further opportunity, the matter shall be listed for fresh admission in the week commencing 20/7/2024. Yes, next.
Pasover item 19.
None appears for the petitioner, though the matter is called twice over. Once when it reached, and again after resumption of the proceeding post lunch. None had appeared. Though it was called twice over on the last date of listing, that is on 24/6/2024. Stop. The matter shall be listed in the week commencing, for orders in the week commencing 27/7/2024, indicating that matter shall be indicating in the cause list that the matter shall be disposed of. Copy of this order shall be forwarded to the learned counsel by the registry. Learned counsel for the petitioner by the registry. Yes, next please.
Item 24.
My lord,
Even for Mr. Sodangi.
no, my
You have
lord,
informed him.
OP.
Correct, sir. I asked you that. Did you inform Mr. Sodangi?
Yes, my lord.
Adjourn कर दियो. You are on behalf of Mr. Sodangi.
Yes.
He wants adjournment. Adjourn to week commencing 3/8.
17.
17 कौन 17/7
My lord.
17/7 तो 20/7 ठीक ଅଛି 20/7 ରଖି ଦିଅ ठीक है.
Sir, our senior is an outer station in that day actually. 27.
20.07.
My lord. Same दिन टिके अच्छी अलका बाहर स्टेट रे.
ଆଉ ଏଠି ଯୋଉ ମେଟ୍ରୋ ଗୁଡାକ ଆସିବ ସେଗୁଡା କଣ ହବ? ସିପିସି ପଢୁଛନ୍ତି? କଣ ପଢିଲେ? କୋଉ ବହି ପଢିଥିଲେ? ଝାବାଲା ସିପିସି ରେ ପ୍ରୋଭିଜନ ଟା ଅଛି due to it has been incorporated that the matter shall not be adjourned on plea of the counsel being busy. ସେ ମନା କୁ 20 ଆପଣ କେତେ 20 କହିଥିଲେ? ସେ କହୁଛନ୍ତି କଣ ତା ଡିଫିକଲ୍ଟି ଅଛି? ୱିକ୍ କମେନ୍ସିଂ 21 ରେ ଆସିବନି କେବେ କହୁଛନ୍ତି ଆପଣ କେବେ କହୁଛନ୍ତି?
Sir, 25.
27 କମେନ୍ସିଂ 27 ସରିବନି ଆଜି ବଟ୍ ଠିକ ଅଛି ନେକ୍ସଟ କମ୍ପ୍ୟୁଟର ରେ କରିଦିଅ. Let's not spend time on this.
25.
You are Miss Mrs. S. Das.
For the petitioner marriage.
S. Das on behalf of Tanmay Mishra for the petition.
No, my lords, I am Trisha Shreyashi. This is
Mr. Trisa Shreyasi.
Yes, my lord.
Trisa Shreyasi. On behalf of Tanmay Misra for the petitioner, LW. It is an appellant. 25 is appeal.
My lord, on the last date, condonation of delay was in consideration. Time was. My lord's OP 124 had taken time on the last date as well, prior to vacation.
You are the project proponent. You are a you are a behemoth, private sector behemoth. So they are small land houses. So,
My lord's just.
and obviously you are challenging their entitlement. So that way limitation, and you must, as you progress further in the profession, why the IA is filed, why the reply is filed, you will realize there are so many aspects.
Yes.
Yes.
My lord's just a request, a short date. It was prior to vacation, if a short date can be allowed.
Short date, actually, we are trying to distribute as much as possible. Listing is not an issue. Tomorrow, every matter can be listed. But up to 27 week, there are already 350 matters. So purpose is that as many can be taken up and which have already been heard, like your matter has been heard. That should get a chance that at least it can be, the IS can be disposed of or taken up. That way, the effort is that only actually. So Bhagavan Mahanti for the state भी party असन दिए yes LA इनको पे आपण
No, my lord.
इनको पे कोई notice जाएगी
IDCO notice was received, my lords. On the last date, it was already.
Why you are not appealing for IDCO?
My lords,
What should appeal for everyone? Our God is there for everyone.
My lords, IDCO is not a contesting party in this.
No, once a respondent, you have to file that affidavit that you are deleting IDCO. Court doesn't have a choice. And in the trial court, the lower court, it must be a party actually.
Yes,
so in appeal, it can't be eliminated like that. Like Mr. Ansuman Sethi, Mr. Bhagavan Mahanti for OP number 1, TO24. Mr. Ansuman Sethi, Arts and Standing Council for OP5. That's all the respondent. That's R. 6 none. The Learned Council for the opposite parties 1, TO24 submits that he may be accommodated further to file objection to the IA seeking condonation of delay. The objection shall be filed. How much time, Mr. Mahanti?
1 week.
The objection shall be filed today. Is, okay. Will be filed by 15/7/2026 upon serving copy thereof on the Learned Council for the appellant and the AC. The matter shall be listed in the week commencing 27.
My lord, if a fixed date could be
Fixed
allowed.
date, you must understand the method.
Apologies, my lord, sir.
No, I'm really apologetic that I have not been able to explain that why the fixed date doesn't work.
No, my lords, I can.
Fixed date doesn't work because they can't modify a judicial order.
Yes.
If it is listed or it is lost. But if you have a week, then you can distribute it.
Yes, my lords. Apologies, sir.
That helps you. Let us see. We commencing 27. Then you file it by 28.
Yes.
File it by 28 upon serving copy thereof on the Learned Council for the appellant. Whenever something is done in your favor, you should be smart enough to not to object to that. Suppose I tomorrow there is a truncated hearing. There are 15 matters left out. So now it is piled up for the next week, so it can be distributed. Yes.
Pleasure.
But of course, whenever a matter is not listed, please mention so that at least we can understand what is happening.
My lord, in item number 26, I am for the appellant, my lord.
Yes, please.
The matter stands posted today for consideration of the court fee exemption petition, my lord. So for LA 14.
Copy has been served, Mr. Devata?
Yes, my lord. Copy has been served from the state council.
IA 29 of 2026.
Yes, sir.
You file your response. Mr. Rabindranath Devata for the petitioner. Project proponent has been made a party, Mr. Devata.
Yes, my lord.
What is the project, sir?
The land has been acquired, my lord.
Executive engineer. Okay.
No.
Mr. Anshuman Sethi, appellant hele Mr. Rabindranath Devata, Mr. Respondent Mr. Anshuman Sethi for R1 and 2, IE 29 of 2026. The IA has been filed seeking exemption from payment of court fee, required court fee. Copy of the IA has been served on the learned counsel for the R1 and 2. He shall obtain instruction and file affidavit on behalf of R2, R1 and 2. By 10 days. Affidavit in response to the IA by 20/7/2026 upon serving copy thereof. By 21 कर दियो तू upon serving copy thereof on the learned counsel for the appellant petitioner. The matters have been listed for orders in the week commencing 27/7/2026. Yes.
My lord, the next item.
Same exemption.
That is also for exemption, my lord.
Secondary say order.
Say similar order will be.
Same R&B. Okay. The learned counsel, Mr. Devata, first line, being present at the virtual High Court of Orissa at Sambalpur, addresses arguments. Yes. Next, please.
Item 27.
Mr. K.K. Maharana. K.K. Maharana for the petitioner.
Last notice has not served.
এটা কোন ଆପଣ କଣ କରାହବ?
Press notice serves.
ଆପଣ same address से बारंबार नियंत्रण. Take some time, but discover the address. Our learned counsel for the petitioner, K.K. Maharana. Office note indicates that the notice has not been sufficient, though issued twice. Stuff. On the first occasion, it was declared unserved. With the postal reports left, lower court se kuche appear korchenti find out. That would be better if you take to the court where the opposite party is appearing. That instruction you have to talk to your learned counsel who is appearing with the family court. And the second occasion, the postal endorsement states court addressee cannot be located. Upon verification, the registry has also indicated that no one is appearing on behalf of the opposite party. Stuff. The learned counsel for the petitioner has adjournment to find out if any other present correct address is if the notice can be issued in the present correct address of the opposite party. For which further 3 weeks time granted. Upon discovery of present correct address, steps shall be taken for issuance of notice in the said address. Unutilized copies shall be utilized. Justice shall do well to fix returnable date afresh and issue notice. Upon furnishing of the details of the present correct address. Liberty to mention. The liberty is granted if you find that any matter the opposite party is appearing. Then simply you take notice, file requisites to the court, serve that court, then that it can happen. Next, please.
Item 29.
Santa Kumar Misra for the petitioner. Mr. Anshuman Sethi for the opposite party. Yes, Mr. Misra.
এটা 2 weeks পরে আসু
Simply urgent कर दियो. पूरा डेट करो.
Who comes in 3 years?
3 years रहबो.
3 years entry motor.
Entry motor कोड stay ना status quo.
Stay ଅଛି.
Stay तले it remains untouched.
Recovery ପାଇଁ ଟା ହେଇଥିଲା.
Stay to stay. At this age, you need not be explained. Age and experience. Yes.
30.
It is not simply it is posted in the computer. That will save time. If the adjournment order thing, obviously renew he କରିବାକୁ ପଡିବ. But if the stay ଅଛି, the stay ଅଛି.
30, 29, 34.
ठीक है. 29, 30 date करें.
Who comes in 3 years? 33,
Posting कर देता है।
application 10.
क्या असली पचाले कहिबे? तो नॉन अपेरेंट सही है। Mr. Mishra, your matter. Mr. Monroe, discuss.
34,
34 भी other side नांती Mr. Mishra. आपन को डरू चंद ना कौन? We were little bit scared of you in the bar.
Right.
आपन को जो style of submission, I mean not scary but very I mean committed. 34 भी date कर दो. Maybe date suggest करूँगी that can be done.
It take good with permission, my lord.
Please.
But what has happened that in different cases has been filed by the under section DBA Act, section 24 and 125.
So that is the usual story.
Right.
All your clients who are coming for they are doing the same thing. So Satan Okila
kindly that is the settled position of the law, even if this honorable court has specifically directed when the evidence affidavit has not been resignation in a case, so that has been remanded. This is the judgment of honorable Justice Saspati, and also
but the problem is that Mr. Mishra, I have been trying to understand this. I have requested almost all the members that when an amount of the Rajneesh versus Neha was dealing with the amount of 10 lakhs, 15 lakhs. But when a 5,000 or 4,000 or 10,000 rupees is awarded, Rajneesh versus Neha nowhere says that unless it is filed, it cannot be done.
I
got so basically when if suppose I am taking that view, you are right. You are right that in many cases it is demanded and done. But if I am taking that view, it has to be supported by some law.
Yes,
Rajneesh versus Neha is not authority on that.
And also the division bench of this honorable court.
But actually what is happening in Mark that even for 2,000, 3,000, so many things are done. Ultimately, suppose it boils down to, just casually, I am not discussing this case. Because in absence of other side, I cannot hear.
I am not on the maintenance, my lord. I am on the point to that the maintenance is granted in 3 petitions, different petitions. Now the total amount will be taken into consideration near about 33 and the salary of 60. So far at the
that point has to be that then what is to be done is that when the first maintenance was awarded, the second was done or not. If the second was there, then when the first was awarded or not. Then the other part is that court is not in a position to click in the computer and get it.
That has been taken into consideration.
Yes.
With your lordship's permission.
No. Kindly listen, sir. Even you may think that I am not prepared, I am prepared. Kindly listen.
Kindly.
Unless you listen, you cannot understand. I did not go into anything. The problem is that then you have to say that
in one petition he has to get, I am ready to pay. It is the duty bound of the petitioner to pay maintenance.
Not one, it's not one, it is the quantum. Suppose the quantum is, the court would think about quantum of 20,000, but already 10,000 is awarded.
No, that is not.
You will not listen, then you will go on speaking.
My respect to submission.
I have to stop talking.
No, my respect to submission before lordships will be. So,
am I disrespectful?
No.
The problem is that unless there is a dialogue or a deliberation, no legal consequence can be achieved.
No, to that.
So taking note of your submission and responding to that, I have to.
No, to that.
Otherwise, there is no difficulty than hard and today there is no hearing at all.
No, I can say like that. To that extent, my respect to submission before lordships will be. I am not disputing not to pay maintenance. That is not my case.
Did the court ask you? Did the court ask you that you have to pay maintenance?
No, that
we are discussing something else. We are discussing the point is that we are discussing that when there are multiplicity of maintenance applications.
Much obliged.
So what is the consequence?
That is the highest award amount that should be disclosed by the opposite party number 1. The law and trial court has to take into consideration which will be the highest amount that should be given. That is my contention.
Yes, obviously.
Yes, my contention is like that also.
You are not precluded from arguing the matter. So
no. I am conscious to that extent. Then thereafter, my lord, the another case has been filed, execution case. For that reason, I immediately filed a petition for stay. If my salary will be attached near about 33,000, so where will you go? How I will be maintaining myself? 3 execution petitions have been filed.
Sir, if the court has considered the earlier application, considered the amount and then granted.
Yes.
High Court cannot say that since 10,000 is granted and
my respect to submission.
No stay. You deposit.
No.
You have to wait.
No, to that extra, my lord, in three cases, my lord. Can I deposit?
Could be 4 cases also. Could be 4 cases. Could be 4 cases also.
Only case I will deposit. So far, near about 40,000 he has already taken. 40,000 here.
What you can do that you take that plea. You take that plea before the executing court.
Man, my respectful submission before this honorable court, this honorable court taking into consideration all this, remanded the matter because the earlier award has not been disclosed by the petitioner at the time of passing the award. So fresh consideration was made.
Second award has taken note of the earlier award.
No, that has not been taken.
Yes, yes.
No, that kindly see. If that is what I have no case. I have no case at all. If that is there, I have no case at all.
You look at
my with your lordship's permission, my lord, I kindly see. That is not there. That's why I am before lordship's matter. May I kindly see that order at page 17. That is my case, my lord.
Stay here, Mr. Mishra.
No. So later we remanded for face Arjuna keeping in view.
Say part of move kari. Eta move jota ठीक भाभी करियो तापर अपन सुप्रीम कोर्ट जी.
Yes. No.
You keep on paying.
My respectful submission.
कौन जेती की maintenance दवा का था दियों तो. If your petition
with permission, my lord, in one case, 125, I will pay the maintenance only, not in respect of others. Let the observation be made.
अपन choice करो तो. You don't have a choice.
My lord.
Choice by law involved नहीं.
No. I keeping with the decision of this honorable court. Yes, my lord, just I am placing.
अपन जोटा पूरा जोटा कहउचंती.
I am placing your worship before the
आपने गोटे पॉइंट जंप करंतु. अपन आगे कोन जे earlier येटा amount टा consider हेनी. केटा देखा.
Just with your worship's permission, I am placing, my lord. That's the division bench of this honorable 2025 1 OLR 922. Honorable Justice BP Rautana and Share Das.
सेटा को पचन. मु भाई लॉ विषय जाननी आपण आगे 42 पारा 12 पे पढो. पारा 11 12 पढो आपण.
हां सर 11% ना पढुची. सर 11% आ गया.
Relevant no 11.
Para 11 of the judgment.
Yes, sir.
Yes, sir. PW1 has also, this is the, my lord, para 11, my lord, at page 15, my lord.
आपण इम्प्यून जजमेंट ର डेट पढ कोन केते
पेज
इम्प्यून जोडा चैलेंज करचोंती जजमेंट ର डेट
8
Recording stopped. Recording in progress.
The petition number 1 has not voluntarily deserted the opposite party, so she is entitled to get is working as a driver in a police department and getting the salary of rupees 40,500 per month. She also stated that the opposite party has agricultural lands and he is earning rupees 1 lakh for annum out of their agricultural land. The petitioner has filed the copy of the salary slip of the opposite party, which is marked as Exhibit 1. From the Exhibit 1, it is found that the opposite party was getting the net salary of rupees 45,056 in the month of June 2024. The petitioner has also filed the information obtained under RTI Act regarding the salary of the opposite party for the period from 1/1/2017 to 31/12/2020. The said information obtained under RTI Act is marked as Exhibit 2. In this case, both the parties have filed the affidavit of assets and liabilities. In this case, opposite party one deposed that the petitioner number 1 is doing job in block office Sahoo and she is also doing private tuition. In the affidavit of assets and liabilities, opposite party has mentioned that the petition number 1 is earning rupees. My lord.
Computer operator na? Sorry, sir. Yes.
Yes, my lord. That wife.
Yes.
Per month by working computer operator. But regarding such income of the petition number 1, the opposite party has not filed any documents. Then para 13, the opposite party has mentioned in the affidavit of assets and liabilities that his monthly income is rupees 26,000. But The Exhibit 1 showed that in the month of June 2024, opposite party has drawn the net salary of rupees 45,556 per month. In the affidavit of assets and liabilities of the opposite party has mentioned that he has voluntarily paid rupees 40,000 to the petition number 1. But regarding such payment, opposite party has not filed any document. The petitioner number 1 has also not filed any document regarding the landed properties of the opposite party. The affidavit of assets and liabilities of both the parties do not disclose if any other case the opposite party has been directed to pay maintenance. This is vital thing, my lord.
Just give me a second.
My lord. Affidavit of assets and liabilities.
Just give me a second. I have to sign, sir.
My lord. Do not disclose if. My lord, sorry to that extent.
Yes, please. So kindly just carefully mark para 14.
Para 14, my lord. This case was filed by the petitioners on 2/4/18. The said case was dismissed for a default on 12/9/2022. Subsequently, the present case has been restored under section 226(2) CRPC on 3/9/2024. So the petitioners are not entitled to get any maintenance for the period from so and so, so and so. In the original petition, the petitioner has paid for maintenance amount of rupees 5,000 in total. Hence, considering the affidavit of assets and liabilities of both the parties and evidence adduced by both the parties, the opposite party is directed to pay maintenance of rupees 3,000 to the petitioner number 1 and 2,000 per month to the petitioner number 2 from the date of the application, that is 2/4/18. Till the date of order of dismissal of the case, that is 12/9/2022. Further considering the enhanced marketing price of essential commodities and considering the enhanced salary of opposite party, he is directed to pay the maintenance amount of rupees 5,000 to each of the petitioners per month, in total rupees 10,000.
Now at least you have read it. So the point I was telling you,
my lord,
that whether this present petitioner who was OPW there, and the opposite party there,
my lord,
had stated regarding he paying this amount and what was the amount paid.
My lord, to that extent, my lord, I want to draw the miscase. I have filed a miscase. I have filed. I have enclosed.
Miscase, written statement.
My lord, 40,000 I have already paid.
Written statement before the trial court.
Trial court I have not filed. That's why it creates
So
a
that is
problem.
how-
Yes, I am
that is how
conscious.
you-
No, I am conscious on the date of filing.
If I am proceeding with, I have to dismiss your case. So today, the adjournment in absence of the other side is beneficial to you. You have no case. I cannot invite people to file your affidavit, all these things, those things. That is contrary to law. Scope of revision is well defined since law.
But I want to draw your attention. This is the position of law.
Drawing me to illegality.
Yeah, your lordship, I have nothing to say about this juncture.
I have to record that your submissions are contrary to record. If you want, I will record them.
But so far as
Mr.
the case,
Mishra,
my lord,
since you are insisting, I can record that your submission on face of it are contrary to record.
to that extent, my lord, I also draw your lordship's attention.
Anyway, since the other side, since I granted you adjournment before hearing you, I will not change. Like you are changing now. When I asked you that, so from the pleadings, what were your pleadings and what you were? Every afterthought is not law, Mr. Mishra.
No, I am not.
It is absolutely illegal.
No. Keeping in view the provision of law, I have filed such a case. When the settled position of law, keeping in view
keeping in view and concealing the facts. Where in an application you have stated that these are the pleadings and the court has not. I have been asking you repeatedly. Where you have stated that. Like one of our esteemed brothers used to say, there can't be any retrial or it cannot be. And still, Mr. Mishra, with your experience, do you know what you can do? You know it. There is a provision. I can't assist you. Still, there is a provision. Because I cannot give a finding that though the petitioner had filed affidavit indicating the payments made, still the court has not taken note of that. There you concede. You are saying that there is nothing. So let us leave it. Next date, Quebec.
We commence in law, sir.
Mr. Manojan Mishra for the petitioner. Opposite party. None. The learned counsel for the petitioner was heard at some length in absence of the learned counsel for the opposite party. He submitted that. He submitted by the learned counsel for the petitioner that the learned trial court has not considered the fact that the present petitioner has been paying maintenance as directed in several proceedings. On being asked whether the present petitioner had filed the written statement or stated in his examination in chief or cross-examination before the learned judge family court regarding he paying maintenance as directed in other proceedings, the amount so paid and details of payment, it is submitted by the learned counsel for the petitioner that that is not the case. Perusal of the judgment of the learned family court judge indicates that the learned court has taken note of the pleadings of the petitioner appearing there as opposite party, his statement as witness as OPW1 in detail. Apparently, as stated by the learned counsel for the petitioner had taken no such stand. The learned counsel then refers to the IA file question.
File number 595 of 2005. 25, sorry.
IA 595 of 2025.
Annexure 5.
Annexure 5, wherein he has annexed.
Yes, sir, that order.
Annexed order passed by the learned
4/1/2025.
Trial court by so and so court. The learned counsel was asked whether the said order was placed before the learned judge trial court, learned judge family court. He fairly concedes that no such effort was made by the petitioner, nor there was any stop. Apparently, there is no scope for the learned judge family court to take note of the order as is sought to be laid out before this court.
With your lordship's permission.
With your permission, may I complete the judgment? The scope of revision by this court has been elaborately dealt with and settled by the Honorable Apex Court in Samima Faruqi versus Shahid Khan. So and so, so and so. Para 20. Para. In view of the law laid down by the Honorable Apex Court, the petitioner cannot rely on any other material that was not before the learned judge while deciding the matter. The view of the as held by the Honorable Apex Court, when the order passed by the learned judge family court is based on proper appreciation of evidence on record, no revisional court can interfere with the reason on the basis that it would have arrived at a different or another conclusion. Yes. Yes, please.
Item 35.
So far the maintenance is concerned, she has received, which I have enclosed annexure 5. 40,000 by that time.
Annexure
knowledge of the fair things has to be
problem. Even if I cannot get a Jahanu law, conviction should be based on some reading. Did you read Samima Faruqi? Have you read? My difficulty is that I have read and have to follow. It is not as your lordship, as law pleases. It can't be my exit by deviating from Supreme Court judgment. And
No.
that too from the Honorable Judge of this court. And the principles have been, it is no new principle. What this court can do in revision. It's very well settled.
Much obliged.
The matter, at least I am obliged that you admit that there is a law. You can say that I do not know what is the case, why the court should
No,
grant
that is not
That
doing.
can be, that
When
can
the law is in my favor, do that extra I place before lordships.
Law is not in your favor.
Are
Law is
your lordship there?
It is submitted by the learned counsel for the petitioner that
Have I gone through those
he is
decisions?
submitting, he is submitting, though not referring to,
Are your lordship?
he presumes that the law is in his favor. Apparently, the statement that law is in favor of the petitioner is a wrong statement of law in view of the law laid down by the Honorable Appeals Court in Samima Faruqi and Rajneesh versus Neha.
Sorry to that extent, with permission, even in this decision of this Honorable Court, that has been taken into consideration in 3 positions. BVI 24, 125. That has been clarified. And thereafter disposal of the direction, the highest amount has to be paid.
Mr. Misra,
Again.
you saw that this court has held that the matter was placed before the learned trial court. Still, the trial court has not considered.
That was remanded.
I have given you a hint. Still, you cannot. The decision you are relying is against you. Right? Because if I rely on that, because the court should hold that even if it is not placed, court has to take note of that. That is not the decision. The decision is against me. Yes. Anyway, this is adjourned because I have adjourned the matter in absence of the matter was had being insisted by the learned counsel for the petitioner. In absence of the learned counsel for the opposite party, the matter shall be listed for admission in the week commencing.
208.
208 है 27 Yes, next.
Please, your lordship.
35.
I appeal on behalf of the petitioner.
My lordship, I am from the OP.
Yes. 35 date कर दियो.
Full counsel 208.
Yes.
It is already totally short through the family court below Bhubaneswar family court. And
से appear court चुनी पड़े. तो adjournment चाहूँ.
My lord, actually we have not get the plain copy. Actually we have get only the order. So just we have need the plain copy for the reply.
Plain copy दे दियो तुम. The learned counsel for the opposite. Your name, madam?
Sir.
अपन को बना करो.
Kalyani Panigrahi.
Ms. Kalyani Panigrahi for the petitioner. You are Mr. Patnaik.
Yes.
Mr. S. Patnaik for the opposite party. The notice has been served and through the learned judge family court Bhubaneswar and is sufficient. Sri Vibhuti Bhushan Patnaik, learned counsel and associates have entered appearance. Para. The Patnaik learned counsel requests for extra copy of the petition as well as annexers. Copy of the writ petition along with annexers shall be served within 3 working days or 2 days.
Yes.
Within 3 working days, the memo indicating such service shall be served, shall be filed in the registry. The matter shall be listed for admission in the week commencing.
208.
208 ही 20 Yes, next.
36.
Yes.
This is a medical dispute between husband and wife for divorce. Petitioner is for the original fruit is the hospital also. He filed a petition for divorce.
Yes.
And wife is the opposite sentence.
What is the order under challenge?
The order is also order from 15/11/2025. It is in challenge agency. Because of the fact agency, as per order 821 of CPC, after receiving the summon and WSS to filed by the party, the lordship within the period of 30 days, not beyond the returning period of 90 days. Now, in the instances lordship of actually served in the CP on day 1, 2024 years. So, this filed lordship 1 day 2020, almost 1 year. Then lordship, the WSS lordship filed without filing in a limitation application or with filing an application for SI council.
WS limitation application, who provision? Limitation in WS, who provision? Which provision?
Acceptance is most necessary.
It has been accepted. Limitation. Question change करो तुम.
This is the
ଆପଣ ଯୋଉ World Cup football ଦେଖୁଛନ୍ତି ଯଦି goal post change ହବ
This is not your lordship.
ଆପଣ 15-11 ପଢନ୍ତୁ order ଟା ପଢନ୍ତୁ
Provision of law with lordship.
15-11 order ଟା ପଢନ୍ତୁ page 45
Advocate for the opposite party filed the hazard counsel picture place for time hard time is given potable process so the president section to the counsel picture filed the position to declare or to file the police of this are failed the case record.
so when the petition was filed on 15-11
yes sir.
when the WS was filed
1/9/2025
correct so kindly then so that fact is correct.
The lordship copy has not been served to me lord. I have no knowledge.
Filing and service copy are different. If you are saying that if copy is not served, that is not filing, that's a different point.
Yes.
But now perusal of the case record, it reveals that.
WS accepted it.
Kindly look at the order.
1/9/2025
Kindly mark order dated 1/9/25.
1/9/25. Advocate petition filed Hazara counts for the opposite submitted WS copy of WS not served. Put up on 8/10/2025 for service of copy of WS and evidence of petition. Then you notes the applicant both by take notes test put up on.
So 1/9 it has been filed. So now kindly mark that service of copy of WS and evidence of petitioner. So once that stage has gone, the court cannot revisit. What you are saying maybe technically, strictly speaking, maybe a view can be taken, but it is difficult in the sense. Now the state order can also be challenged.
Oh, yes.
So it is better you proceed with it. It is better you should go ahead with evidence and complete the proceeding. Then if you are agreed by the ultimate order, you challenge it. But it is a very difficult proposition. What you are propounding is a very difficult proposition.
It's very much clear that your lordship regarding filing the documents and that period of limitation has been
You have to place on record any decision or any provision in CPC which says that it cannot be accepted.
It can be accepted.
Correct.
But your lordship, there must be some application, your lordship.
It is understood to have been accepted. You must understand that. Once the order dated 1/9/2025 has been passed, then 15/11 you could not have passed. 15/11 19 ଆପଣ କୋଉଟା ରିଲାଇ କରୁଛନ୍ତି ପଢନ୍ତୁ kindly place the provision you are relying on.
Order in 2 orders. The defendant shall within 30 days.
ठीक है, ମୁଁ ଏତେ quick नोट ଟିକେ Yes.
The defendant shall within 30 days from the date of service of summons on him present a witness statement of his defense. Provided that where the defendant fails to find the witness statement within the said 30 days, he shall be allowed to file the same on such other day as may be prescribed by the court for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of summons.
Yes.
Now you not say 90 days period over
17.5. Look at order dated 27.3 and 17.5. Start with 16/12/24.
Yes, 27/3.
16/12 ରେ ଆରମ୍ଭ କର। 16/12 ରୁ ଆରମ୍ଭ କର। 16/12/24।
Panel counsel of the parties filed as a put up on 27/3 for concerned counseling report and filing published during training.
Yes.
27/3/2025 advocate petition filed Hajira. Constitutional report is received, but it's reported that constitution is failed. Opportunity fails for type to file of days. Add for type.
27/3 ରେ add କରନ୍ତୁ 90 days.
Your lordship, the law says.
Your lordship, no, ଆଜ୍ଞା 90 days ରେ law ସେଟା ଯୋଉଟା law କହୁଛନ୍ତି ସେଟା ଆପଣ fairly cite କରୁଛନ୍ତି 27 ଦିନରେ 90 days add କରନ୍ତୁ।
27 ଦିନ 90 days add କଲେ lordship
ସେଟା ତ କୋଡ ହିସାବ କରିବେ ଆଉ କଣ 27/4 ଆପଣ ଦି ଜଣ କାଉନସିଲ ତାଙ୍କର ବି କଣ ମ୍ୟାଥମେଟିକ୍ସ ବୋର୍ଡ ଆସୋସିଏଟ ଭଲ ଆସୋସିଏଟ ଅଛନ୍ତି 27/4 27/5 27/6 ତାପରେ 17/5 ରେ ଆପଣ ଦେଖନ୍ତୁ 17/5 ରେ he has been granted time.
Advocate for the opponent failed for time to find of this petition next stage have time is allowed for one
So ତାପରେ ସେ time allow କରୁଛନ୍ତି। The problem is that in all occasions you are present, time is allowed in your favor. So technically, what you are saying, if this court goes, then this order will be very fragile, very what you call very delicate order. It can't sustain. ये order टा challenge हेले गला. This order is very difficult. अपन जोड़ा कहूचोनी maybe to take your proposition, it can be taken. It is a proposition, perhaps arguable point, but it is very बहुत weak. और strength नहीं छिड़ा.
I have to cite some judgment.
There is no judgment as upon cite करता है. Knowing you would have cited their judgment. अपन का matrimonial matter रे conciliation is a mandate.
Correct, Lord.
Conciliation is a mandate.
Mandate, Lord.
So now suppose after that he prays for time for either husband or wife, prays for WS tribe, court grants it in your presence. Then time is expanded.
Order 821 said there is not the date of.
But ଆପଣଙ୍କର ଯଦି ଥିବ ଯଦି without so then if you mark for reasons to be recorded in writing, the court has said that time is prayed for and time is granted. So that is the reason.
That means there is not indefinite period.
Not indefinite. You have woken up after 27/9 after it is accepted. 1/9 it is accepted. 1/9 it is submitted. And Mr. Jena, if you apply this law strictly, I don't know how many cases in the matrimonial causes there will be WS can ever be entertained. And you never know TRPC tapare file hito. TRPC habo file habo out kon hoch file ye file habo. Writ petition. RPFM sab chalibo. Obviously.
Let your lordship do one thing that trial will happen.
Seta haboni.
Because now the evidence test, it is there in the evidence.
Like Mr. Misro was saying that
because the case record says that now the evidence test.
Constitution bench achi. Constitution bench achi. Co decision. Which Constitution bench decision has strongly deprecated, in fact, has said that no court can pass target any suit. Who Constitution bench? Kindly check Allahabad Bar Association, which has set aside all your ACN list for resurfacing. Para 37. Para 43. Supreme Court revision that even if a different view can be taken, it cannot be. That we are discussing. But if I start taking different view, cannot be. So
I have a case of lordship. What seems a lordship?
You see, you must understand that then this will be carried to Supreme Court and remanded for acceptance of written statement. Because rejection of written statement or debarring written statement is a harsh measure. It is in terror. Usually. But एथिरे कौन है ना टाइम कंसिडरेशन फेल्युअर है टाइम नेले रिजनेबल बेसी समय जाय नि तापर आपण को टेक्निकल पॉइंट सिटी आसी गला बट सेतेबेले आपण कंडक्टिंग काउंसिल यस ठीक अछि तब आपण ठीक करछ यू हैव डन द राइट थिंग नल सीए ठीक आस्ता वेरीफाई करिया हां जदी से ग्राउंड रे डब्ल्यूएस से माने डिबार हे थांता इमीडिएटली दे वुड हैव फाइल्ड इन सो हाई. You have done the right thing.
But order 821 says that from the date of appearance of lordship, that the limitation has to count the lordship.
Generally, especially was
failure of conciliation.
Generally, especially was non-derogate. Family court has a special statute.
Yes, my lord.
As far as possible.
But the procedure.
As far as possible. No. CPC.
Section 10(3), my lord.
Conciliation is a mandate. Otherwise,
that's correct.
The entire proceeding is vitiated.
Conciliation.
So conciliation even. तो conciliation ने बेले वर्षे पड़ुछ. You would mark that conciliation TRPC RPFM रे पड़ुची वर्षे.
High Court रे पड़े तोलो कोटा के तीनटा डेट
obviously दोना दी कहना ताको ऊपर High Court ताको we are breathing on their neck. Supreme Court is breathing on their neck.
3 days.
Supreme Court and we are breathing on the neck of the Judge Family Court. चिखाई pending अच्छी. We are having those statistics every month. We are verifying that. You have done the right thing is not objecting because conciliation in Family Court Act, without conciliation, no matter can proceed. Sete gote bhabiyo padibo. Hard noted counsel for the petitioner. The petitioner, Mr. Prabhas Chandra Jena for the petitioner, Mr. S.R. Das for the opposite party. The order dated 15/11/2025 passed by the Lord Judge High Court Qatar. In CP number 61 of 2023 is under challenge. By the said order, the following was directed. Hello. Prior to the said order, the relevant orders that order dated 27/3/2025, 17/5/2025, 29/7/2025, 1/9/2025 and 8/10/2025. The said orders being brief are reproduced here. The learned counsel for the petitioner refers to Order 8, Rule 1. Which is reproduced here, Order 8, Rule 1 of the CPC. Are amended till date. For convenience of reference, the said order is reproduced here. But relying on the provision contained in Order 8, Rule 1, it is submitted that in the case at hand, it is apparent that the written statement was accepted beyond the period as mandated in Order 8, Rule 1. Learned counsel for the petitioner is apprised of the fact that till 27/3/2025, the Learned Judge Family Court had to retain itself, awaiting the report of conciliation as mandated, report of conciliation between the parties as mandated in Chapter 4, Section 9 of the Family Courts Act.
In your WS having no connection with the conciliation orders.
In any case law, it is submitted by the learned counsel for the petitioner that filing of WS has no connection with conciliation. In considered view of this court, the such submission is not correct. But the fact that if the parties conciliate and agree for a settlement, the written statement would be of no use, nor can be referred to by the learned court in learned family court in deciding the matter. से दोनों तो आपनकर written statement deny करते हैं. आपनकर 13 चाहूँ फाइल कर 13 रे से दोनों तो ground of cruelty है. Desertion cruelty.
That is the other to make factoring fraud errors.
Fraud है ठीक है. से आप cruelty है. Cruelty. से cruelty deny कले. और WWS से तार conciliation कौन हो? आपनकर effort is that you may end up in filing a 13B also. Conciliation can be result in a 13B application also. Before when the matter is taken up, adversarial conciliation is always better. Once it becomes adversarial, conciliation doesn't work.
That's true. Conciliation or see bound errors.
Yes.
Conciliation bound errors.
Conciliation the purpose is so if you are finding fault that if you are making that proposition, then that without going for conciliation, written statement should have been praised for. Then that has to be considered in that context. At this stage, the learned counsel for the petitioner submits that after acceptance of the written statement, the matter should be expedited. Stop. The learned counsel for the opposite party submits that the written statement was accepted after conciliation failed, and time sought for by the opposite party in presence of the petitioner therein was allowed by the court for filing of the written statement. A strict construction of the Order 8, Rule 1 would lead to a situation where, in a matrimonial proceeding, where two lives are impacted, the version of one of the parties is denied. आपनकर स्ट्राइकिंग ऑफ प्लेट रे से हाव सी हेडु काले से कहबे जे स्ट्राइकिंग ऑफ प्लेट ई जो पार्ट रे होउची बट ए केस रे मैट्रिमोनियल मैटर्स रे मैट्रिमोनियल मैटर्स रे आपनकर मैट्रिमोनियल मैटर्स रे it becomes very difficult for both the parties and for the court also. For the court also. Denied the opportunity of placing his or opening her case. Defense. Having heard learned counsel for the petition, the petitioner as well as the opposite party, in considered view of this court, the order dated (192025) accepting the WS cannot be faulted with. Accordingly, accordingly, the subsequent order dated 15/11/2025. No, 1 evidence is like. The order dated 1/2025 accepting the WS and directing the matter to be posted for evidence of the petitioner cannot be faulted with. Stop. Accordingly, the subsequent order dated 15/11/2025 need not be interfered with in the facts and circumstances of the case. Before parting with the case, it is observed that the parties shall cooperate in proceeding diligent in the matter without taking unnecessary adjournments. The learned judge family court shall do well to deal with the matter in accordance with law. Stop. The petition is disposed of.
Much obliged.
Yes, please.
This I
am appeal of the opposite party. I prefer next to that one week after.
Yeah, the case is section 1820 of the adoption and maintenance. Mother has filed the case. Then your lordship can recollect order was passed. Then I filed matter, and the matter was heard by Honorable Justice Sinha and your lordship. It was remanded back. Then I filed an application to implement the younger brother as a party who is an advocate. Now I am a pension holder, retired person. That has been rejected. That is the supplemental challenge.
Civic time in absence of Mr. Mahanti.
Oh, dead.
The Bodhidhara Park senior advocate along with Mr.
Last order
Manas Ranjan Bag. So Manas Ranjan Bag for the petitioner, Mr. Fine. Mr. PK is fine. For the opposite party, the learned counsel for the opposite party seeks adjournment in absence of the learned arguing counsel. The learned counsel, the senior advocate for the petitioner submits that the matter has already travelled to this court and has been remanded back. Considerable time has elapsed, and matter may be heard. Stop. To grant for the opportunity to the opposite party, the matter shall be listed in the week commencing 10/8/2024.
Entry order to continue after 10/8. The Lord's kindly see last.
If you have adjournment,
Again.
the learned senior advocate draws attention to the order dated 5/5/2026 and submits that the interim order may be reiterated. Stop. Accordingly, it is directed upon a press para 3 print कर दियो तो उधरे अपन केबे डेट कले मिस्टर बारी
We council 10/8.
shall be adjourned to a date beyond 17/8/2026 as would be convenient to the learned court in season of the matter. The matter shall be listed for admission in the week commencing 10/8/2026. Again,
Order number टा
अच्छा typographical error. I would be order भूल ହେଇଥିଲା कोठी आस्तल. Office note put up by the registry indicates that inadvertent typographical error has crept into the order dated order number dated 5/5/2026 wherein the order number has been typed as 01 instead of 03. The order number shall be corrected. I would go through order actually correction and actually list correct confirm. Yes. Yes, please.
38.
I filed for Lordship to call this matter next week along with our IA.
So Sarat Chandra Samal for the petitioner.
My lord.
Yes, please.
My lord, this is the third time adjournment. And
We have filed IA for your Lordship person. But IA asked for next week.
এটা কোন মানে সুপ্রিম কোর্টে
Supreme Court to dismiss it. We have filed IA for compliance of the
কপিটা দিয়ন্তু
copy already sir.
copy just
SC Samal for the petitioner, Mr. Naik for the opposite party, additional standing counsel. It is submitted by the learned counsel, additional standing counsel that IA has been filed on behalf of the opposite party, copy of which has been served today on the learned counsel for the petitioner. The matter shall be listed for admission along with the IA in the week commencing
10/8.
जल्दी जाओ जल्दी
again
27/7
कर दो 27 कर दियो तो कौन जदी कि नहीं कि सुप्रीम कोर्ट पर कहीं केटा को ट्रैकिंग इट
He has already received payment 1 crore 18 lakhs something. Only the case with regards to interest. They have only entitled only interest, only decided only interest.
to see the
आपण 1 crore पाहिजे जदी तो
again
ताले काय व्यस्त होचो आपण ताऊ बदन इन्वेस्ट करी कि ये करंतु
again interest in the again order
it's a dream for many in this country.
this is
ये करिया एक्सक्लूड करिया
Yes.
नहीं again
नहीं आपणकर सुप्रीम कोर्ट रे कन्फर्म होला पर ठीक पर सुप्रीम कोर्ट रे फेल करिया पड़ो आपण सेठी नै जिथांते से ऑर्डर टा
से तो डिसमिस ହେଇଛି ସେଠି डिसमिस ହେଇଛି ତାପରେ ମୁଁ କଣ୍ଟେମ୍ପ୍ଟ ଫାଇଲ କରିଛି
1 crore ପାଇଁ ଏଟା थाउ 10/8 एटा थाउ
ଆଜ୍ଞା ନାଇଁ ସେ ପିଟିସନର ହେଇଛି ଇନ୍ ଦ ବେଡ୍ ହଜବେଣ୍ଡ ଆଣ୍ଡ
1 crore ପାଇଲା ପରେ ତାଙ୍କର ତ ହବନି ଆଉ ରିକଭର କରି परिबेନି He's in shock.
ସେ ଆଜ୍ଞା ସେ ବଞ୍ଚିଥିବା
he's in shock. Unless he's a businessman or entrepreneur or he goes to Malan Street for as my senior says or the honorable judge.
My lord, at the end he has to pay because this is the order of the honorable.
ସେ ତାଙ୍କ 1 crore ରେ ଶୁଣନ୍ତୁ ବର୍ତ୍ତମାନ ତା ଦେହ ଭଲ ବାଜେ ସେଠି ଟଙ୍କା ଥାଉ after receiving
ଆଜ୍ଞା ଘର ନାହିଁ ସେ ଆଜ୍ଞା ଘର ଖଣ୍ଡେ କରୁଛନ୍ତି ଘରେ
ଏଥିରେ ଖଣ୍ଡେ ଘର ହବ ଏଥିରେ ଆଜ୍ଞା ଯୋଉ କଣ off market 4.5 BHK ସେଇଥିରୁ ହବ
ଆଜ୍ଞା ଯାହା ହେଲେ ବି ତ ସେ he must get it.
At this age he is in shock actually. You be considerate about his health and welfare. ठीक ଅଛି तापर एटा भी टैक्सेबल होबनी आ गोटे जिंस होची बोधे कोर्ट रे आपण जेमति जानतो कोन बनेगा करोड़पति तार 30% टैक्स 1.15 रे इनकम टैक्स पडला
এটা কত কোন হিসাব মানে জানি সে he has already received 1.18
see my area salary
1.2
1 point something see that is my area salary
ଆଜ୍ଞା ବହୁତ ଦିନର କୋଟିଏ ଟଙ୍କା ମୁଁ ପାଇଛି ମାନେ କେତେ ବର୍ଷର ସାଲାରୀ ବାକି ଅଛି ମୁଁ ଇଣ୍ଟରେଷ୍ଟ ଆଣିକିରି ଚଳିଛି
ସର୍ଭିସ ଲ ବହୁତ କରିଛି ମୁଁ ଫାର୍ଷ୍ଟ ଟାଇମ ଦେଖୁଛି ଏତେ ଟଙ୍କା ଇଏ ହବ
ଆଜ୍ଞା ଟିକେ ଏଲିୟର ଡେଟ୍ ହଉ
ସାର୍ କଣ ଆପଣ ଯୋଉଟାକ କଣ୍ଟେଣ୍ଟ କମ୍ପ୍ଲାଏ ହଉନି ତାକୁ ଆମେ କରିକି ଚେଷ୍ଟା କରୁଛୁ କରିବା ପାଇଁ ଠିକ ଅଛି ଆସୁ ଡେଟ୍ ତ ହଉଛି ଲିଷ୍ଟ ତ ଯାଉନି
ଆଜ୍ଞା
ଦେଖିବା
ସାର୍ ସେଇ 27/7 ଥାଉ
27 ପର୍ପସ୍ ଆକ୍ଚୁଆଲି ଶୁଣନ୍ତୁ ଆପଣ ଯେତେବେଳେ କହିଲେ 27 ମୁଁ ଆକ୍ଚୁଆଲି କରୁନି ତା ରିଜନ ଅଛି sir already there are about 120 matters so there is a method that is being adopted up to 27 week ଆପଣଙ୍କର 350 matters have to be adjusted already adjourned
ଆଜ୍ଞା
ତା ଦେହରେ ଫେର ଅନ୍ୟ matter add ହବ ନା ନାହିଁ so ଖାଲି list add କଲେ କଣ ହବ sir ପଢିବା ଦରକାର
ସାର୍ ଏଇଟା ମାଇଲଡ ଏଇଟା ଲାଷ୍ଟ ଚାନ୍ସ ହଉ ତିନିଟା
ଲାଷ୍ଟ ଚାନ୍ସ କଣ ଆଜ୍ଞା
ଏଇଟା ଥାର୍ଡ ଟାଇମ
ସେ ଆଜ୍ଞା 1.5 କୋଟି ପାଇଛ
ଈଶ୍ୱର ହେଇଯାଉଛି କିନ୍ତୁ ଆଜ୍ଞା ସେ କେତେ ବର୍ଷର ଦରମା ପାଇଛି ଇଣ୍ଟରେଷ୍ଟରେ ଚଳିଛନ୍ତି ଆଜ୍ଞା ସେ ଜଣେ ରିଡର ଇଣ୍ଟରେଷ୍ଟରେ ଚଳିଛନ୍ତି
ବର୍ତ୍ତମାନ ଚଳିବ
ହୋଲ ଲାଇଫ ତାଙ୍କର ଇଣ୍ଟରେଷ୍ଟ
ମୁଁ ଜାଣିଛି ଆପଣ ଯଦି କହିବେ ଆଇ ଟେଲ୍ ଦ ଟ୍ରୁଥ ୟୁ ୱିଲ୍ ବି ସକ୍ଡ ସେ ମାନେ ତାପରେ ଟ୍ରକ୍ ବିଜନେସ କଲେ ତାପରେ ସେଟାକୁ ଇଏ ହେଲା ତାପରେ ଦେହ ଖରାପ ହେଲା ଆଣ୍ଡ ତାଙ୍କର ଅବଶ୍ୟ ତାଙ୍କର ନିଜର ଦରମା ନୁହଁ ତାଙ୍କ ସ୍ପାଉସଙ୍କ ଦରମାଟା So I come to know how you know because a lawyer knows everything.
Again,
so when you start dealing with cases, you know.
କୋଟିଏ ଟଙ୍କା ଆଜ୍ଞା ଓନ୍ଲି ସାଲାରୀ ଏରିୟରଟା ତାମାନେ
ଆପଣଙ୍କର anyhow 1 crore 20 lakhs by any means is a big amount.
ତାର ଇଣ୍ଟରେଷ୍ଟ ଦେଇଛି ସେ ଇଣ୍ଟରେଷ୍ଟରେ ଚଳିଛନ୍ତି ନା
ଇଣ୍ଟରେଷ୍ଟ କେତେ ଆପଣ 1 crore
ଆଜ୍ଞା ଗାଉଁଲି ଇଣ୍ଟରେଷ୍ଟ ଯାହା ହେଇଥିବ କୋଉଠି 12 କୋଉଠି 10 ବଞ୍ଚିବେ କେମିତି ଖାଇବେ କେମିତି
ସେଟା 12 କଣ କୋର୍ଟ ଅର୍ଡର ପଚାରୁଛି ଆପଣଙ୍କୁ ସେଟାକୁ ପଚାରୁଛି ଆପଣ ଗାଉଁଲି ଇଣ୍ଟରେଷ୍ଟ କଣ let us see
interest 6% again this is the court order 6%
ଦେଖିବା next one
my lord
okay
10 8